And recording has begun.
Good morning, and thank you very much for joining us today for the open session of the Privacy Consulting Group. We're going to call the meeting to order. And a note for everyone present that a remote meeting, like a regular in-person meeting of the Privacy Law Group, is recorded and will be archived on the State Bar's website. The Privacy Law Group will take items on the agenda in the order that they appear on the agenda. Votes for any items will be taken by roll call. We're going to begin with roll call. Janelle?
Choi,
Present.
Davis,
Present.
Persons, Isri,
Present.
Jaworski,
Present.
Calais, Karanian,
Present.
Krolik,
Present.
Lanoy,
Present.
Martinez, Rajmahan, Serrato,
Present.
Unaka. We have quorum.
Thanks very much. This is the section for a call for public comment. The Board of Trustees recently adopted a public comment policy that applies to all State Bar committees, including this one. Its policy statement says the State Bar of California welcomes public comment at all of its public meetings and appreciates listening to a wide range of viewpoints that reflect the diversity of California. Those public comment rules are designed to ensure that members of the public may exercise their right to be heard, as well as ensure that the State Bar is able to fulfill its obligation to conduct public business on behalf of the people of California in a timely fashion. Written public comment may be submitted to the email address on the meeting agenda. We encourage you to submit written public comment at least 24 hours prior to the start of a meeting. Written comments received less than 24 hours prior to the start of the meeting will be distributed the following business day. If you bring written materials to a meeting for distribution, they will be collected by the meeting secretary and distributed after the meeting concludes. For oral public comments, persons were encouraged to sign up to speak in advance of the meeting and will be called in the order that they have signed up. Persons attending the meeting remotely will be called in the order that they appear in the attendee list. And in a moment, I'll explain how to raise your hand to tell us that you want to do that. Speakers cannot cede their time to another speaker. It does not guarantee that all who wish to speak will be able to do so to facilitate hearing from as many members as possible. We encourage you not to repeat points that were made by previous speakers. Simply say that you agree with them to allow the committee the time needed to deliberate on the important topics that we will be discussing today. We'll be limiting public comments to 3 minutes per person. As a reminder, the State Bar's anti-discrimination and anti-harassment policy says the State Bar maintains zero tolerance for unlawful harassment, discrimination, and retaliation. Employees must at all times treat all other employees, job applicants, and persons providing services to the State Bar with respect and dignity in accordance with this policy. Likewise, the State Bar will not tolerate harassment, discrimination, or retaliation against its employees, job applicants, or members of the public by any employees or by any person with whom the State Bar has a business service or a professional relationship. If you are in Zoom and want to speak, you'll need to raise your hand unless you are already in the pre-meeting sign-up list. To do so, you click on the hand icon that's at the bottom center of your Zoom window. If you're participating by telephone, you may virtually raise your hand by pressing *9. That's the star key and then number 9. Our coordinator will call members of the public starting with the pre-signups, then the Zoom list, followed by in-person signups in the order that they raise their hands or signed up. Staff will enable the microphones of the speakers, start the timer, and then call out when 30 seconds remain. Do we have anyone that wishes to make comments? We do not have any pre-signups.
We do not have any pre-signups and I do not see any hands raised.
Okay. And welcome again, and we'll go ahead and start with the minutes. We're going to begin with the approval of the January 25, 2024 public meeting minutes approval. Has everyone had a time to review? If so, do we have a call for a motion to approve?
Motion to approve the January 25th, 2024 minutes.
And I second that motion.
Thanks very much. We're going to vote by roll call to approve the January 25 public meeting minutes. Janelle, please start the roll call. Janelle? I think you're on mute.
Sorry. Choi,
Approve.
Davis,
Approve.
Hersensen, Isri,
Approve.
Jaworski,
Approve.
Kalei, Karanian,
Approve.
Froelich,
Approve.
Lanoy,
Approved.
Martinez,
I was not present at the last meeting, so I'm not
Same.
sure whether I can approve or not.
You can, but it's up
Okay.
to you.
I'll approve.
perfect, thank you. Rajmohan, Serrato,
Approve?
Unaka. With 10 yays and 0 nos, the motion passes for the minutes.
Okay, thanks very much. At this point, we're going to move to section 3 on the agenda, which is the business. We're going to start first with item on the agenda A, which is the review and discussion of member research regarding potential privacy law exam specifications. We're very excited to start the discussion today. And again, I thank the members of the consulting group that have been working on this tirelessly for the last few months. As you know, we have been working for the last, I guess, year and a half in taking a look at the need and the demand and interest in privacy law specialization with the State Bar of California. And today we're going to be discussing the member research in what those exam specifications could include. So let's start with the first item, which is the U.S. private sector privacy certification. Here is an outline of the body of knowledge for the certified information privacy professional in the United States. That is hosted by, managed by IAPP, the International Association of Privacy Professionals. And we have the staff thought that it would be helpful to start with this as one of the examples, as IPP provides this exam for CIPP, which can be used as an example for how a privacy certification may be done. And so again, this is provided as background material as we continue to have the presentations from the consulting group of one of the examples that we looked at. So on this page, we are seeing here, this is the list of topics that are included in the IPP certification, which is called the CIPP. If we don't have any discussions there, we'll go to the next slide. This is still the continuation of the CIPP. Again, we see the list of topics here. These are generally the types of topics that are going to be included in the CIPP for the US exam that is managed by and certified by the IAPP. Let's go to the next slide. This is still the continuation. We're going to give we'll give just a few, just a little bit more time so that the members have a chance to look at the continued list of exam specifications that are including the CIPP. Let's go to the next slide. This is still the IPP example for the exam specifications. And again, a reminder for everyone who is joining us live that the slides and the materials that the group has consulted and the video recording of this today will be available on the State Bar's website in case you want to take a look at these materials more closely after our meeting has concluded. Let's go to the next slide. And next. And next. Next slide, please. And as we are looking at what the CIPP exam includes, I think just a quick heads up, a teaser, I would say, is that a lot of these topics are going to be discussed by the consulting group as part of the exam certification that we are going to propose for the California State Bar. So I think we're definitely seeing an overlap in the topics that will be covered with our group's presentations. Let's go to the next slide. Right, we have the state privacy laws and the discussion between the federal and the state, inclusion of the security laws. Let's go to the next slide, please. And the data breach notification laws. And I know that this was one of those topics that we talked about previously, how the privacy certification includes security issues. And let's go to the next slide. Okay, so that concludes the examples from the CIPP and taking a look at the topics that are included in the IPP privacy certification, which is available put out for the private sector. We talked about how the IPP certification is open to all private sector, not necessarily just the attorneys. We talked about that being one of the distinctions of the privacy certification program the California State Bar would provide. Second example that the staff wanted us to consider is the example of exam specifications as provided by Harvard Law. And so again, here we have some presentation here in terms of what the Harvard Law curriculum would include. And it is titled Data Privacy and Technology. And this is a course that we would that the staff wanted us to consider in terms of what an exam specifications may include. Let's go to the next slide, please. Okay. So here, this is not a certification program, like the one that we just talked about with IPP. This is, again, a law school course. So it is meant to be instructions by the law school. And I would say, setting aside Harvard Law, we have many law schools in California that have a privacy certification and have privacy law courses, including in the schools that are represented by the consulting group members. Okay, so you can see here different modules and discussion about what is privacy, the data collection, data use, and data reuse. Let's go to the next slide, please. Talk about the technology and the intersection between technology and privacy, the price of privacy, and the cost of personalization, some of the case studies, and taking a look at how to apply in a practical business setting. Let's go to the next slide, please. And what's coming. I think it is helpful to take a look at how some of the course offerings not only talk about existing laws, federal, state, and global, but also keeping an eye on the emerging technology issues and what is coming, anticipating the legal landscape changes in the area of privacy. Let's go to the next slide, please. Okay. So exam specifications, professional responsibility. So now that we have taken a look at what the IPP looks at for their certification, and the second example that the staff wanted us to highlight, which is on the Harvard Law School's syllabus for certification in this area by the law school, we're going to begin discussion with item number 3, where we are going to start presenting on the exam specification, based on certain subtopics. So we're going to start with Mariah highlighting the research and the proposed exam specifications for the professional responsibility. Mariah?
Thank you. Hello, everyone. As Jiwon mentioned, I was tasked with looking into and proposing an outline for exam specifications as they pertain to professional responsibilities, specifically the ethical and professional responsibilities of a privacy specialist. The sources that I evaluated, interestingly enough, the IAPP, I think in part because it is not only limited to attorneys, but can arguably be a certification that non-attorneys get. We don't see as much discussion of ethical and professional responsibility in the IAPP text. So instead, I focused on existing specialization certifications in both California and other states and how they laid out their professional responsibility sections of those certifications. I also looked, of course, at the ABA model rules. I also consulted some sort of third-party sources, including academic resources. The proposal essentially is what you see on the screen, and I can walk us through each specific section and subsection. But the first section is to discuss the ethical obligations of a privacy specialist. Here we will talk specifically about the duty of competence. So that's going to be specific to being competent in the privacy laws of the state of California and potentially nationally and internationally, depending on how the certification advances. Discussion around the duty of confidentiality that attorneys have and how that duty of confidentiality is specific in the privacy sector. So what does that actually mean as a privacy specialist? How are we specifically tasked with holding client data and other resources confidential? The duty to supervise and inform, that's specific to our use of associates, of paralegals, of legal support staff, and other third parties as we perform our larger privacy specialist obligations or work. We have the duty to oversee and monitor those who work and leverage and whose resources we leverage. And then interestingly, and I think worth inclusion is going to be an emerging duty that we see some state bars, including, for example, the New York State Bar, come out with guidance and sort of circular letters around. And that is the duty to notify clients in the event of a data breach or an inadvertent disclosure. So that's section 1.1, ethical obligations of a privacy specialist, the sort of four main component parts. I don't know if I should pause here and allow for discussion.
Sure.
Sure.
Does everyone have any questions or comments on the presentation on the professional responsibility exam specifications? Okay. If we don't have any comments, then we'll move to the second area.
So the second area in the professional responsibility section is going to be data practices that we recommend to support the ethical legal practice of a privacy specialist. I think this is slightly new and emerging also, and I just want to note that. But the idea here would be that as a privacy specialist in our practice and potentially even in the larger legal environments in which we operate, whether that's in-house, whether that's with a law firm, et cetera, maybe we have obligations to engage in exercises such as data minimization, right? To be asking ourselves, to be encouraging those we work with to take careful look at why we're collecting the information we're collecting and to make sure that information is reasonable and proportionate to the various needs of our engagement. We should also be able, I believe, to speak to administrative, physical, technical, and other controls that a privacy specialist should know about that help to safeguard client data, right? So a privacy specialist is someone in the organization who can be called upon to discuss, generally these APTs, and that having APTs in place is part of the ethical duty of a privacy specialist. And then I added vendor management. I mean, I think that that includes everything from understanding how to enter into like BAAs with our healthcare clients potentially, or how to just have contracts, DPAs, and other agreements in place if we are leveraging vendors. So that is the 3 component parts of the second proposal, which is to hone in on those data practices that can support the ethical legal practice of a privacy specialist. And I will pause here for comment.
Hey, Mariah, just for clarity purposes, would you be open to spelling out any acronyms here?
Sure. So APTs, I believe that might be the only acronym I see. That's going to be those administrative, physical, and technical controls that we would be looking at. And it could be everything from having policies and procedures in place with your organization to working with an IT counterpart to understand physical and technical controls such as firewalls and MFA, et cetera. Obviously, we will need to flesh out specifically what types of APTs a privacy specialist could be responsible for, but I think it's more just generally, right? Like a privacy specialist should be aware and capable to speak on actual practices to safeguard client data. I believe.
Just for, again, we're kind of taking a look at how this is going to present in terms of the exam specifications. If you wouldn't mind also just spelling out vendor management.
Sure. So vendor management in general is going to be the practice that we as attorneys undergo when we engage different vendors. That can be everything from like our Microsoft contract, when we leverage Microsoft and O365, when we use Slack or Teams, to vendors specific to e-discovery, if we're a law firm that has functions like litigation functions, et cetera. Or if we ourselves are considered potentially a vendor to our clients, or if we ourselves are asked to enter into agreements such as business associate agreements with some of our healthcare clients, right? So it's the idea that we need to be capable of understanding when we share client data or when we share data with third parties in connection with our legal work, what obligations and contractual provisions that might require.
I have a question for you and Ryan. In preparing this, how did you think about so 1.2, the data practices, for all 3 of those topics, I am going to assume that a number of other presenters that are going to come after you, they're also going to talk about these as requirements for businesses. How did you kind of think about, what falls under professional responsibility and individual responsibility for, let's say, the privacy specialist versus the obligations that apply to the businesses? And, of course, there's going to be overlap, but to what extent are, I guess, the future sections that we will discuss, let's say data mapping, if there is a data mapping requirement for businesses and it's going to be tested, let's say, and in the different part of this exam certification process, how would the professional responsibility section look different?
It would be much higher level. It would be much more conceptual. And it would be really just identifying the role that a privacy specialist would play, ideally, in encouraging the use of data mapping or encouraging, for example, the evaluation of data minimization in their organization or to their business clients. But again, the meat of what is data mapping, the component parts of what is data minimization, that should be in other sections. Here,
Yeah.
it is just a practice that enhances our ethical obligations.
Okay.
If that makes sense.
I'm just kind of trying to think through how will we test that, right? Are we going to test that the privacy specialist knows that these are concepts that are part of the ethical, legal practice? Or are we going to test, what data mapping and minimization legal requirements are there that apply to the businesses? You know what I'm saying? So I'm kind of trying to think about what will we actually test under 1.2? Because I know that when we were preparing for these presentations, we did not have the advantage of, for example, the federal draft, privacy bill that was unveiled just 2 weeks ago. And that draft bill, for example, talks about a particular privacy officer and information security officer being appointed, right? And it talks about particular reports that have to be prepared by and signed off by and reported by privacy officers and the CISOs. So, maybe this is something that we can keep in mind. I think Mariah and Ryan, you had the hardest job of going first. And so as we move forward, with the other presentations, and at the end, this is what I would like to propose, is that after all of the presentations have concluded, maybe we can come back and say, which of these obligations that apply to businesses belong in which section, because they're overlapped, and maybe there will be a cross-reference, from section 1 to 1. Section 5, for example, versus which ones are applied to the individuals, which I think is the way I'm thinking about professional responsibility.
And I think that's very fair. I want to clarify to the extent it wasn't crystal clear. I do think at the individual level, a privacy specialist has the obligation to ensure that they or their organization is safeguarding client data. So I do see the individual application of this. And I could certainly see questions that address that individual obligation.
That are separate from the business obligations.
That are separate from the business obligations, correct.
Okay. Any other questions or comments on 1.2? If not, we'll go to 1.3.
Great. So 1.3 was truly a proposal, whereas 1.1 and somewhat 1.2 we see in other bodies of knowledge. 1.3 is really sort of my own independent and with consultation with Ryan's kind of proposal on how we can address the idea that these ethical issues of a privacy specialist are evolving, and some are emerging in large part because of the environment that we live in today, with the rapid advancement of various artificial intelligence applications, et cetera. So I thought to propose, but I'm really interested in the committee's thoughts, a section that deals specifically with attorney use of AI. Of course, you may be aware that various bar associations have already sent out guidance on attorney use of AI and the ethical use of AI. We have various standing orders from judges throughout the United States about potential disclosures that you need as an attorney to make to both your clients if you use AI, and then also to the court if you are leveraging or relying on AI to generate documents and to generate drafting. So I do think, at this point in time, it makes sense to have attorney use of AI as a standalone section. However, over time, I could see it becoming a little bit more embedded in the other duties, for example, the duty of competence. But at least initially, for some period of time, I think it's worth its own standalone section.
Thank you for your thoughts on that, Mariah. And I would say this is another area, I'm looking at the rest of our topics. I believe we have a separate Soyan is going to be presenting on the emerging technology. We also have the intersection section. So I could readily see a discussion about this 1.3 having some cross references and some overlap with those two. So I think this is very helpful to think about professional responsibility. And I think as we hear from the other presenters, we'll think about, holistically, which of these issues fall under professional responsibility versus, should we have that be dealt with in some of the other sections. So I would ask the members to keep an open mind. Thank you very much, Mariah, for your presentation on the professional responsibility. As you said, I think this is probably one of the sections that are going to distinguish our certification process from some of the others. So thank you very much for the cutting edge work. If there are no other comments, we will move to the second presentation.
Jiwon, can I add one more response? Maria, I just wanted you to know, maybe you already knew this, that also the California State Bar has been working on an AI policy as well. And maybe you were referencing that earlier, but I just wanted to add that.
I
Mhm.
think
Or-
California is one of several states that is in progress, and other
Mhm.
states have already, Florida, New York have issued. So I agree, Amy, and I think recognizing that in our professional responsibility section would make a lot of sense.
Great,
Mhm.
thank you.
Thank you.
Yeah, and I'm paying attention to how this is phrased, because again, this is what's going to remain in terms of the exam specifications on our certification, right? So I'm sorry, if we can just go back to the last one. Please pay attention, I would say, to how Mariah is phrasing it, which is, emerging ethical issues in privacy and technology. That's how we phrase it. And then you are proposing to specifically call out AI, attorneys' use of AI, and then new technology. Those are the terms that you are proposing. I think we're going to see in the later sections, how we talk about these. And at the end, I think we should think about how to use these terms in a consistent way, right? So for example, I am curious to hear what Soyeon is going to present in terms of emerging technology, new technology versus emerging technology, right? Those are the kinds of things that I think we're going to need to work together as a group after the presentations have completed, so that we are using the term consistently. And if what you are proposing is different and it's not the same, then we should highlight that they are not the same. But if they are, trying to address similar concepts, I would propose to use the same term, from section 1 to section 5, for example. That would be my proposal. So keeping that in mind, let's go to the next section, which is going to be presented by Lindsay. And Lindsay is going to be highlighting for us the research and the proposed exam specifications for the privacy principles. Lindsay?
Thank you. Yeah, so just a backdrop. In our last meeting, we talked about starting with privacy principles, because many of the laws that have been codified have taken into account these privacy principles or practices. And I think that you'll see many of these topics again repeated by later presenters. Actually, if you wouldn't mind going to the next slide, just because what this really is, I think this chart, you will see some of the different guidelines and laws that we examined. To Jiwon's point, the draft American Privacy Rights Act was not released when we put this together, but I think that many of these topics appear in that draft as well. You will see that these principles vary, but there are major themes. And so these are the 10 principles that we mapped to. I will note that there is an 11th principle that we thought we would bring to this group for discussion around risk assessments. And the reason why we did not put it on the list, Ryan and I discussed this, is because we felt it was slightly more operational than a principle, but it's something we can discuss. So maybe I'll just, before we discuss that, if you can just keep that in the back of your minds, maybe, Jiwon, do you want me to go through each of these with a little more detail?
I think that would be helpful. So are these 10, going back to the previous slide, are these the same 10 from the previous slide?
That's right, they are. Yeah.
Okay.
And you're welcome. If you want to go back to the other slide, you can.
I just want to make sure. So if it's the same
Yeah.
list, then I think that's fine, and we can just have this. The chart is super helpful, Lindsay. Thank you so much for doing the work. So yeah, we can go back to the chart, since I think it gives us an idea of kind of the breadth of the research that you have done to land on these 10, right? So I think it will be helpful for you to go through. And again, if I may, just kind of talk to us about how we would test. We're trying to put together an exam, right? And so, how would you propose to test on notice principle. That's going to be different than, let's say, I think the next section is actually going to be Paul presenting on data collection. So I know that part of the data collection, I'm sure Paul probably will be talking about, let's say, notice, right? So if you can kind of talk a little bit about how would you test for the principles that might be different than some of the legal requirements that our future presenters will be discussing.
Yeah, sure. And I think, you know, as a overarching comment, I would say there's kind of two options. One option would be we test on these principles. What are the 10 principles? And sort of at a high level, what do these principles mean? Or we could organize, just make sure that the exam is organized in a way that reflects these principles. So I think there's options for how we do that. So, but I think, let me just go through the each one and maybe we can see if there are suggestions or discussion based on, what the exam might be.
Could I also just ask just a logistical question to the State Bar staff? We're going through these different topics. The exam specifications is going to be used to prepare the actual exam questions, but let's say notice. So let's say one of the principles is notice. It does not mean that the exam has to have a question on notice per se, right? This exam specification is meant to kind of provide a universe of the topics that the exam could pull from. It is not required to have an exam question in each of these subtopics. Is that right?
Correct. I think the idea is to define the scope. Like ideally, all of the areas that need to be covered in this privacy law. But it would be impossible to add all of them. It's just defining all of the parameters, and obviously you would they would change from one exam administration to another, or you would have multiple questions that you would pull from for this exam.
Got it. Meaning, I think I'm just logistically, I'm trying to, think about our task at hand. We don't have to necessarily solve for this problem, right? We don't have to necessarily solve for the fact that, the concept about notice shows up in principles and in all of these, US state requirements, FTC requirements, global requirements, but we don't have to solve for the fact that this also shows up in Paul's presentation next, which is under data collection, right? It's okay to have these overlapping principles. Is that right?
Yeah, absolutely.
Okay, thank you for the clarification. And sorry
Sure.
to interrupt, Lindsay.
No problem. Thank you. Okay, so actually the first three and also number 9, I'm going to kind of group those under a concept of rights of individuals. So notice is generally referred to as openness or transparency about what policies and procedures are taking place with respect to individuals' personal information, how it is used, collected, retained, disclosed or shared, etc. And you will see different laws referring to notice as being transparent. Choice and consent and opt-out has to do with describing the choices that are available to individuals with respect to their personal information and what they can do to either provide their implicit or explicit consent for collection, use, retention, sharing, etc. And I think this is especially important for disclosures to other vendors, as our previous presenter was mentioning as well. The access, or sometimes called individual participation, has to do with providing individuals with access to what personal information businesses have. about them for their review and potentially update or correction. And then number 9, the non-discrimination. This is a slightly new right of individuals that we see in some of the newer laws. As you will see, we did not examine all of the US state privacy laws, but we took the first kind of 5 that have come on the scene, and of course, California and some others here that you see listed. And this is really about not discriminating against individuals for exercising their rights with respect to personal information. I'll pause there and see if there's any comments or questions.
I'm going to see if anybody else has questions. If not, I do have a couple of questions for Lindsay. Okay, everyone, feel free to jump in. My question for you, Lindsay, on one, notice and transparency, I think those are the terms that I see most often. Could you educate me on which of the laws talk about openness as, something that is, in the same vein as notice and transparency? And what do you mean by openness?
Yeah, I mean, actually, I don't have the list in front of me as to which one uses that term. Happy to go back and find that out for you. But my recollection is that that's a bit of a older term, I would say, right? In some of the guidelines, and just stepping back, these fair information principles, the FIPS, sometimes they're called fair information privacy practices. They've been around since the 1970s. And so some of the language has kind of evolved. So I don't think we see the term openness so much anymore in the modern privacy laws, to your point. We see the notice and transparency.
Right, right. So that's kind of what I was thinking about is, how do we want to, and I think it's fine if you think openness has different concepts that are not included in notice and transparency, right? To the extent that openness brings a different angle, I think it is worth discussion. But I think most of the modern, privacy laws today would fall under notice and transparency. And so I wonder if openness is subsumed within the newer terms, which is notice and transparency. So that was my first question, just for us to ponder. And then you talked about individual participation and the right to delete. The word delete is not on this chart. So do you think delete is in the consent and choice number 2, or are you thinking the deletion right would be under individual participation number 3?
That's a good question. I think that it's, probably the concept could fall under both. It is, but deletion kind of happens later, right? So I think the consent and choice concept and opt-out is I think of that generally when, at collection. And then number 3, the access and individual participation is, opt-out could happen later, right? That's sort of still exercising your choice, but it's sort of later in the life cycle. So I think, deletion you see, generally around that in the access and individual participation column.
I really like the way that you explained it. I think what you're alluding to is kind of the data life cycle, right?
Yes.
So there are particular principles that attach to when the data is created or when it's collected versus, there is kind of the middle part of the life cycle, how it's used, to whom it's transferred, and whether you have a right to be forgotten, for example, do you have a right to be, opt out? Those are kind of the use and the maintaining of the data. And then at the end of the life cycle is, when does the data get deleted? When does the data disappear, right, from being in circulation? So I think you're right. Some of the principles that we're talking about are probably, again, in more than one bucket. It does not, neatly fall under number 2 or 3. And then number 4, obviously, accuracy is related to that. To the extent that you have inaccurate data, you need to get it, reversed. So you need to get it corrected. So the question about redress, I think, is very important.
Yeah, absolutely. And I can talk more about number 4 and number 5 next. I don't know if other people have any comments or questions about the rights of individuals, number 1, 2, 3, and 9 at this point.
Hi, hi, this is Soyan. First of all, thanks for generating this chart. It's really, really efficient and helpful. I had a question just about the 2.7. I don't know if I'm jumping out of order or anything, but just because there looks like there is a editing choice where it says purpose specification / collection and then limitation / focus collection. Are those illustrative sort of oppositional? I'm just wondering what the extra space is for.
Yeah, I mean, I think it's a little bit in line with the question that Jiwon had about the term openness. I'm using a few different terms for each of these principles, and one thing that we could do is just decide on one term that we want to use throughout, rather than these 3 different alternatives. In number 7, the reason why it's titled purpose specification, collection, limitation, focus, collection is because those terms are used in different privacy principle codifications. And what I did was try to kind of map similar concepts across this chart, because they don't all use the same words. So that's what that's about.
Oh, thank you. You know what? I also read it wrong. I'm sorry. I
No worries.
apologize. But thanks for the
worries.
clarification. I brain fart. Thank you.
Michael has a hand up.
Oh, yes, Lindsay, you did an excellent job. One of the things I was hearing, or just came to my mind, is probably unauthorized data. What I mean by that is, when I'm programming, I have to be aware of PROCOPA, the Child Protective Rights and Laws, and it's just something which just a small smidge of I believe you can collect some, but not a lot of data. You have to get parent permission in some states. Just another category of data unauthorized. Or I don't know how you want to phrase that or frame it, if at all, but that's just a data type that I was thinking about when listening to everybody's excellent comments about it. Again, Lindsay, you did a great job with the chart. So thank you.
Thank you, Michael. I think, and I did not map COPPA onto this, but I think it could be, maybe categorized under number 8, data minimization and proportionality and use limitation. I think what you're bringing up is interesting in terms of authorization, though. I don't know if anybody else has any other top. I mean, also number 7, I guess, the focus collection, could be captured under that as well. If others have comments about Michael's question, happy to hear them.
Thank you for that. I think 7 and 8 could be included for authorization or whatever. But no, thank you.
And as the group knows, because of the Badgley-Keene Act, this is really meant to be a subgroup. I know Lindsay and Ryan are working on this. And, as we move forward with the rest of the topics and the exam specifications, I think I think we'll have the advantage of the whole group, the entire consulting group, being able to think about the question that Lindsay, you're proposing. You know, I had the same issue on the topics that we were working on as well, is that I think that's why kind of the fullness and the comprehensive nature of your research is so helpful, is that you're bringing to us and say, look, you know, these 10 things are not in every single law, right? And I think that's what's so incredible about our consulting group's exercise here, is that we are really trying to create a comprehensive set of exam specifications for a privacy specialist that is spanning across, you know, all these global standards across time. And the terms are not the same, and the principles are not the same, and the way that the principles are interpreted have changed over time. And so I think that's what's so incredible about this exercise, and it's just an honor to be working with you on this. You know, since I want us to have the other topics to have adequate time as well. Maybe Lindsay, you could go ahead and continue to clarify the rest of the 10 principles, and we'll see if the group has any other comments or questions.
Great, thank you. Well said. Okay, well, the next two that I wanted to just quickly go over, number 4 and number 5, are really, I would bucket them together, about controls on the information, and what organizations can focus on. So accuracy and quality is really about maintaining accurate and complete and relevant information, personal information, for the purposes that have been identified in the notice to an individual. And that could include the right to correct. This is another one where the principles sort of cross over into, you know, choice, number 2. Information security is about using reasonable administrative, technical, and organizational measures for and physical safeguards to protect personal information against unauthorized access or use or sharing or modification. And number 6 and yeah, I'll just talk about number 6 quickly, which is really, you know, accountability, which is a broad term. You could think about that as monitoring and enforcement. So organizations should be monitoring their privacy practice compliance with what they have set out in their policies and procedures, and have procedures to address privacy-related complaints and disputes. And then there could be enforcement by regulators to bring compliance in line with what organizations have promised to do. Number 7 and 8 are, we've discussed these a little bit, but I think going into them a little bit deeper, and I know that we're going to probably talk about these a lot in future future topics. So the focused collection, I'm just going to use that as a shorthand for number 7, even though we talked about the different terms are used. This is about collecting information really for a specific purpose. It does go along with number 8 around data minimization and proportionality and the use limitation. And again, these terms are used differently in different laws and different principles. And I'll just highlight that data minimization really, which is, you know, again, kind of related to the focus collection, but in terms of using, or in terms of collecting only the personal information that is really needed, but also using the personal information only for the purposes that is stated, that's reasonably proportionate. You see the you see this appearing in different laws in different ways. And there's quite a large focus, I would say, on data minimization in the new federal bill that has been proposed. And we see, I think, a lot of activity even at the California level talking about the importance of data minimization. So I think that's a key one to call out. And then the last one, storage limitation. We've talked about this a little bit in terms of the life cycle of data that Jawan, you brought up, which I think was very helpful. And just thinking about how long we're keeping data, I think is in some ways a new concept. As you can see from the chart, the storage limitation is not something that appears necessarily in some of the earlier principles that have been around for a long time, although you could view it as a part of security potentially.
I have a question on number 10, because I think another way to talk about storage is retention.
Yes.
So, you see the word retention appearing as kind of as analogous to the storage limitation requirements that you discussed. But I also don't see on this 10 principles maybe data transfer requirements, or rather, geographic storage, questions. So not only, how and how long, let's say, data is stored, but where it's stored. I think it's increasingly an issue. Specifically GDPR cares a lot about that. And so I wondered if you thought about expanding the storage limitation to include where the data is stored.
I think that's an excellent point. And I would be happy to think about expanding that. I think that makes a lot of sense as to where it could sit. Of course, there's in terms of it could appear under other principles like choice, for instance, or the individual participation. But I think expanding it in the storage limitation or retention could make a lot of sense as well.
And I'm looking at the rest of our topics. We have the topic on data security, the data use and data sharing, and I think the cross-border data transfer issues. As we saw in the latest federal data broker bill that was just enacted yesterday. There are, I think, moving kind of trends in terms of trying to limit the sharing of data across borders, especially to companies that are of concern. So I think that would be something that we could think about in terms of the storage, where the data is transferred to. And I am looking forward to the discussions in the later presentations as well. We're at 11 a.m. now, and so again, I'm just watching the clock and making sure that we're going to have enough time for the other topics too. Unless we have more questions and comments for Lindsay, I would like to turn to Paul for the next section. Okay. Paul is going to present to us his research and the proposed exam specifications for data collection. Paul?
Hi, everyone. So Ryan and I looked at data collection, and when we compiled this list, we tried to look at the key elements that any organization will have to consider when they, when they collect data. And in relation to this, there is a lot of overlap, like you mentioned, G1 earlier, a lot of overlap with what was already said. So I guess, I won't need to go into the details for each item because Lindsay already provided a lot of background for that. So that's good. In terms of, the different components. So the first component, I think, should be the notice, right? The notice of collection, because that's essentially what is, that's the only way that an individual is able to know what information is being collected. That is the public facing, if I may call that way, that's the public facing information which is provided to users. And, I think that the components of a privacy notice will be an essential thing that any organization should know, and any privacy professional should know. And in terms of notices as well, that's something that we see in so many different privacy laws around the world. They may not necessarily have the same complexity as the GDPR or the CCP or whatever, but then in so many countries around the world, there is this requirement that you have to provide information as to what information you're collecting. So that's why it's an essential element. So, without going into the details as to, everything that a privacy notice should, should include, because that's also jurisdiction specific. Some of the components, I think, which merits, for the in deeper dive would be, the newer technologies which are used for, for tracking, whether it's cookies, whether it's web beacon tags and so forth, analytics as well, because that's something that so many organizations are using nowadays in order to assess how many users are on the website, what users are doing, which which components of the websites are more popular and so forth. So analytics, because it's so widely used, it is something which needs to be considered as well. And of course, geolocation data, because in many cases as well, you have a number of organizations who would wrongly assume that, oh, we don't collect GPS data, so therefore we don't collect geolocation data. Well, that's not actually accurate, because in reality, a lot of organizations, they do derive some geolocation data from the IP address and other other data that they collect. So some information in this respect, I think, would be useful. And then I talked about the website privacy notice, but then it's the same for an application, an app, whether it's a mobile app or whatever. Those should also have information as to what information is collected. And you do have different tracking technologies which are used in relation to apps, and those should be specifically addressed in the app privacy notice, as well as any software development kits, any use of application programming interfaces and so forth, to the extent that those entail a collection of data or the disclosure of data as well to any third parties. And then, of course, location data. I mentioned earlier GPS location data. That is something which which is more specific, I would say, to mobile devices. Going beyond the privacy notice, looking at the key principles, again, which Lindsay has already mentioned earlier, those are fundamental in terms of data collection. So data minimization, what does this concept mean? Because it is something which we are finding in more and more US and in worldwide privacy requirements as well. What does it mean to collect only what is needed for the purposes of the processing? Purpose limitation as well. That is something which is a common feature, I would say, of so many different privacy laws. Indicating what data would be collected and is processed, and limiting yourself to whatever you have disclosed. And then if we transparency, disclosure requirements, that's also something which which is fundamental. And here, from a California perspective, I think it is important to mention CALUPA as well, because before the CCPA was around, we did have this this privacy law, which actually is still around. It's still it hasn't been repealed or anything by the CCPA. So I think some mention of it at least would be important, especially because it was as well mentioned in the recent enforcement action by the California Attorney General's office. If we go on to the next slide.
Before we do that, can we
yes.
just take a look at the first slide,
Sure.
if you don't mind? I'm just going to ask for anybody to raise any questions or comments.
That's a great question. For time, I'll be quick. I like the fact that you noted app privacy notices, especially with software development kits, SDKs, and APIs or application programming interfaces. One quick note is that some may know I have my own programs on the Google Play Store, and it's interesting because I'll just provide commentary about how it's very difficult to provide proper notices without any guidance or minimal guidance from the actual usage of some of the libraries and classes provided even by Google and other companies. So it will be very interesting on how we can test that. One of my interesting hypothetical question could be, here's what this program collects or libraries. What type of notices do you have to provide? Is it global? Is it minimal? It's very interesting on because it gets into, is it shared by first parties or third parties, and then what type of data is being shared and for what reasons? And it's all checkboxes, which is compounding on how difficult it is because there's no guidance or minimal guidance, I should say, on how to do it. But yeah, that's a very interesting thing.
That's a really good question. I would say that since you mentioned the Google Play Store, and it's the same as well for the the Apple App Store. You do have actually guidance issued by Google and Apple as well in terms of what they expect. And those I call them guidance, but it's actually a bit more than a guidance because if you don't comply with the rules set out by Apple or Google in relation to the App Store, then they can, if they choose to, they can actually kick you out of those app stores. And yeah, I mean, there have been some incidents where some organizations said, well, they complied with their own local local laws, privacy laws, and those local laws may not have been as stringent as what you have in the EU or even in the in some US states, and those apps were still kicked out, and they have been asking questions, why is that? And the answer is, well, yeah, if you want to be on those platforms, they have the right, if they choose to, they have the possibility to enforce stricter requirements if they want to, and if you want to be on that platform, then you have to abide by those rules, otherwise they can kick you out. So this is an example, I think, of cases where you do have requirements which may be imposed, which are not necessarily due to applicable applicable laws for the company, if you can demonstrate that GDPR or other privacy laws don't apply, but then then again, if you think about how the app stores work as well, you do have when you choose to upload an app, you actually also choose typically which geographical region, right? Because if your app, for example, is entirely in in Malaysian, for example, you're not necessarily going to want to have that available on the US App Store, because it doesn't make any sense. So and you do have quite a number of apps which are local, and in those cases, yeah, they can simply just comply with the local rules. But then when you upload the app, if you say, well, I want it to be available globally, then you do by doing that, you're also subjecting yourself to global requirements, while this in the requirements of the laws where the app is available, simply because now you're making it available in those in those jurisdictions. So it is always a question of well, where are you making the app available? And in those cases, well, you're subjecting yourself to the laws of those countries.
And real quick, I know Lindsay, you have your hand up, so sorry. Just a quick commentary. Users can also sideload your app. And
could you repeat that?
Users can also sideload your app.
Yes.
So I have 5 years ago, I had people illegally downloading and re-uploading my apps on different stores, which I'm not putting myself out there for that, but other than if there is people to the end, so it's just interesting. But Thank you.
It's a very interesting conversation. I want to make sure that we are focusing our debate on the data collection legal requirements for the exam specifications. So Lindsay, do you have a comment or a response to Michael and Paul's discussion specifically, or do you have a different point? You have a different point.
Different point.
Okay, then let's just close, I think what Michael and Paul were raising. And Paul, just to kind of follow up on what Michael was raising, are you thinking, and I absolutely agree with you, that the app stores have a role to play? For our purposes for exam specification, are you thinking that the exam should test on for privacy specialist functions, right? So I'm a privacy law specialist. Do you think that the privacy law specialist exam should test on what the Google or the Apple stores require, or should we include exam questions based on just the legal requirements?
I think we should focus only on the legal requirements because requirements from app stores can change at any time without notice, right? And it's also up to them how they actually enforce their own requirements. Because this is an exam from the California State Bar as well. I think that it should focus more on legal requirements as issued by the state bar, sorry, by the state of California, or otherwise, federal requirements or the legal requirements which come from other countries, but just laws and regulations.
Thank you for clarifying that. So if I'm looking at 311 and 312, what that represents is what are the legal requirements for websites and what are the legal requirements for apps in terms of notice at collection? Is that a correct way of summarizing that? Okay, great. Lindsay?
Thank you. I just wanted to make a comment about section 3.4. I think it's really helpful, Paul, that you called out CalAPA because the CCPA threshold analysis is something that always has to be done, and many startup businesses in California will not be subject to CCPA, but they will still have requirements under CalAPA. So I guess I have a question based on that, which is where we, or maybe it's something for us to think about, is where will we be testing on the CCPA thresholds? And I just think it's very important that we highlight CalAPA. So thank you for including that.
Maybe could I expand on that? Because Lindsay, in the previous presentation, we talked about how there are notice requirements across all the other, laws too, right? Different states, different, jurisdictions like GDPR in the EU. So, Paul, for 3.4, were you thinking specifically transparency and disclosure requirements for CalAPA and CCPA only, or were you mentioning them as examples?
Just as examples.
Okay. So I think we talked about in general, what we want to do is we want the exam specifications to stand the test of time. And so to the extent that, let's say, CalAPA or CCPA is going to be revised, amended, etc., would you be open to leaving the title to be transparency and disclosure requirements and removing specific laws, or okay. Or I was going to say it's fine to include them as a subtopic to let them know this is one of the subtopics within transparency.
No, I mentioned those in brackets just for illustration purposes. We don't have to keep it in the title.
Got it. So administrative to the State Bar staff, again, this is something that I ran into, with our working groups as well. What is the level of detail that we should put together for the exam specification? I think the original instruction during the last meeting was that, so you got, level 3, right? 3 data collection, and you got the 3.1, that level, the first level, where we have notice that collection, data minimization, purpose, and transparency. Those are the 4 topics under data collection. I think the original discussion was that that's where the exam specifications would stop, right? It would go to one level below data collection. Everything else, like the examples about CalAPA, examples about cookies, web versus app, that would be for research purposes, and that will be for discussion and illustration purposes, but would not necessarily end up on paper for the exam specifications when the certification program moves forward. Could you clarify whether that is correct or not?
I think what's really important is to specify to the extent that you think it's something that needs to be drawn out for the exam. So my concern with leaving it at the point of, for example, 3.1 notice at collection and not specifying whether it's the web privacy notice or the cookies is you might lose some of that specification. I don't think it hurts for you to provide that level of detail down to the cookies. And it's not required for every single one, but I think that as long as you have that specification, it just will, I think, create provide the detail that the level of detail that is significant for this. So my concern is not providing it is that you might miss out on some of this. So if you already have that, the idea that should be a source, I don't think it's it is an error to include it in the specifications.
Got it. So moving forward, our full group, what we should be discussing is what level of detail needs to remain, right, on paper versus what is for really discussion and illustration purposes. So for example, what I was going to ask Paul was, did you and Ryan discuss that there are notice requirements that are outside of websites and apps, right? So you got connected devices. For example, the law that got passed, yesterday talks about immersive and immersive and augmented technology applications. There are different platforms and environments where notice of collection is going to be required. And again, I think we need to take a look at, not to box us in, right? When we say notice of collection, we don't just mean websites and mobile apps. We also mean offline too. There are many laws that talk about offline privacy notices. And so I wondered, what level of this detail did you mean to kind of remain in the exam specifications versus which of these are illustrative?
Well, and I think the other way to think about it, sorry, if I can add one more comment, is that part of what we're evaluating here is should California embark on developing its own exam as you're comparing also current exams that are being employed in other areas. And so perhaps the level of specification that you have in here is part of that evaluation. So if you don't see it in other exams, it's a way of helping evaluate whether California needs to establish their own exam. And so that's another reason I recommend keeping that level of detail in here. So
that is helpful. So you're saying actually more details that show how this certification is different than other certification could actually help with the state bar make a case for creating its own certification.
Oh yeah. For this group to make that determination, because this group is going to be making a recommendation to the CBLS. So this level of information may better inform this unit about that evaluation.
Whether this separate exam is needed because it covers perhaps content that is not covered by other exam certifications. Having said that, I think because I know that we've talked about this several times already. Isn't it true that there is no privacy certification that's allowed for California licensed attorneys today? So there is no peer, certification program that we could compare ourselves to.
Well, and part of it is because the field hasn't been defined, right? I mean, that's the intent of this group. So the idea, though, is, the different models that we've talked about in the past, where you have, in some states, they use the ABA exam and then have their own. I mean, that's one option for California. Like if you compare the level of detail that you seek to cover in terms of the scope of an exam, and match it up against ABA, anything's outstanding, you could create just simply a California component and borrow from the ABA, or just create your own exam to begin with. So those are the things that need to be evaluated here. And I think that's why the specifications are going to be important.
Okay. That is really helpful. And just so that everyone is on the same page, when you're talking about the ABA has adopted the IEPP. So IEPP is a certification body. There is no other ABA privacy certification. ABA has adopted the IEPP certification, and IEPP is a certifying body which has the CIPP designation. So just make sure that everyone is on the same page on that. So you're saying, Amy, that that part of what the State Bar is considering, because I think that is really helpful for us to know, is that the California State Bar could decide that having IPP as a certification body is one of the avenues.
Yes, but when you say the State Bar, again, we're relying on this working group to make that determination or make that recommendation, because the way that the determination will be made is the CBLS has designated this group to seek a proposal on how we will evaluate on the criteria for a specialization, on the exam specifications. So you will use this information to make that recommendation. It'll go to the CBLS and then to the board and for adoption. So again, it'll inform you as much as anybody else who needs to make this decision as it moves.
Adrian, could you speak on this, because I think this is really important. I thought it was made really clear during the last meeting that our tasking was to create a separate exam that is going to be administered directly by the State Bar, and that the State Bar is not asking us to evaluate other certification programs. Isn't that right, Adrian?
So the ask was to draft out the exam specifications and the requirements for a State Bar specific one. And I think what Amy's mentioning is, like, if you're unable to, there may be like an alternative path. But right now,
I see.
the ask is like, if you can, and if we can come up with the State Bar specific exam and certification requirements, that's what it would be. But like Amy said, like if we're unable to, whether it's through research or comparison to other programs, the recommendation may be something else. So
okay, this is different. I did not know that was part of our consideration. So thank you for clarifying that for us. And I want to make sure that everyone in the consulting group heard what I heard. So let me just say it back to you. So Adrian and Amy, are you saying that today, this consulting group, as we're moving forward, we're in the middle of presenting the exam specifications. Our task is to take a look at the list of exam specifications that we would propose for the California State Bar if we were to create our own certification program. If this consulting group cannot reach agreement on the set of exam specifications that we would recommend for the California State Bar to adopt as a new certification program, then the State Bar could take a look at other certification programs, for example, the ABA-sponsored IPP certification. Did I say that correctly?
No, I think that you're correct in terms of the level of defining the specifications. We're looking to this advisory body to define the specifications. And then the next part is in terms of a recommendation on how we will test for those specifications, how we will examine candidates for those specifications. This group should make a recommendation. For example, if you looked at the IEPP and said, hey, comparing the level of specifications that you want in an exam, and it's not a complete match, then you design your own exam. It could be part of that recommendation. What we're trying to do is ensure that you have all the tools that you need to make that recommendation. Once you've made the specified what should be the content scope of the exam, then the next part is determining how you test for that. So and so the only reason I'm bringing up the IEPP or any other tools that are out there is just so you have all of the potential sources, but it's up to this group to make that determination as a recommendation.
Okay.
You could adopt
that
it.
is very helpful. So again, just to kind of focus on the tasking at hand,
Sure.
I want to make sure we're on the same page. Today, as a group, we're discussing if there were to be a privacy certification program for California licensed attorneys for the California State Bar, and our recommendations, that's what we need to discuss, right? So the next step, as you said, Amy, is going to be about the testing and the exam and the different qualifications. Today, what we're discussing is what should that exam test, right? And what is the level of specifications that we want to include? So I think the question comes back to Paul and others for us to talk about is, do we want to spell out that there is a specific privacy notice requirement for the website, for the mobile app? What about offline? What about immersive technologies? Should we leave it open for the different kinds of notice at collection that would be required? Should we go down even further to spell out that maybe there's a cookie notice, there's a pixel notice that's maybe different than the cookie notice? So I think that's what we're discussing, and what you're highlighting, Amy, is once this group has agreed on the scope of the exam, then the next tasking will be to talk about, okay, how are we going to test it? And part of that how are we going to test it could include taking a look at how the other certification programs test for qualifications. Did I get that right?
Absolutely. That's it, Jiwon.
Great. Thank you
Okay.
very much. Appreciate it.
Sure. Mhm.
All right, so back to Paul. Paul and Ryan, what would you recommend in terms of, what you want to have remain on paper, right? So again, kind of the two goals that I see here, and one is that you want the exam specification to test, stand the test of time and not be, so limiting, right? And allow for the changes in the laws, changes for, technology innovations and whatnot. On the flip side, the reason for having more granular detail is that this allows us to really kind of provide instructions on what this exam includes. It talks about how maybe this exam is different than some of the other certification programs. And so I think you have those two kind of conflicting goals. So on the one hand, to be high level enough to allow for changes, and then on the other side, be granular enough to really kind of specify why this exam would be a value add to the community. What do you think, Paul, for the data collection piece?
Yeah, when in relation to the categories which are listed here, those were only intended to be, the most common examples, right? For example, in relation to the app, not everybody thinks about that, but then it's a requirement. But then, like you mentioned, because you do have, so many, new technologies which are emerging and so forth, do we want to necessarily spell out that we need to do it for this and that? It's a bit too much. So maybe, we can, scale back or at least clarify that, it's not intended to only be in those two scenarios. Maybe we can just, change it to mention more privacy notice and examples, and that would be it. And then it would be up to, not necessarily go into the level of detail as to, in which cases you need a privacy notice, because like you mentioned, we are going to be limiting ourselves due to the emergence of new technologies.
Thank you, Paul. All right, any questions or comments on this page? If not, we'll let Paul continue with 3.5.
I have a quick question, and it's not to belabor this issue of notice of collection and the level of specificity, but it does seem very much focused towards online, to an
Yes.
earlier point. And then also when I think of notice of collection, I also think about employees. And now I think about, the employee notice requirements under like the CCPA, for example. And then I also think about notice under the HIPAA context. So I know that some of that's going to be a struggle because, not a struggle, but I know that because we decided on a principle-based outline, that this is just going to be a sort of a dynamic that emerges. But I do think as currently conceived, where the notice of collection should at least include like offline an employer personally.
Yes.
Yeah, I think that's right. And so I think, again, the push and pull here, right, is that, we could have pages, of all the different notice requirements, or do we say notice requirement and know that the testing can come from all the different notice requirements, all the different industries, all the different data subject categories, and all the different environments, whether it's web or app or offline. So again, I think that's going to be our next task, I think, is to kind of think about how this slide in terms of how we talk about notice. And, to Lindsay's point, maybe notice and transparency go together. Like maybe those are two things that are same, right? So I think kind of making sense of the principles and then using the same terminology for the data collection, notice and transparency requirements or openness requirements. I think that's going to be the next level, is to kind of really synthesize and streamline between the different presentations. Any other comments? If not, Paul can go to 3.5. All right, Paul.
Okay, okay then. So in relation to the slide, so collection from third-party sources is something as well, which which is crucial. And again, the examples provided here are just examples. It's not intended to be an exhaustive list. So maybe in the future we need to to shape this a bit differently so that it's made clear that we don't only limit ourselves to social networks, advertising companies, and data providers, but then those are common examples which are used by a large majority of organizations. But then technologies evolved and so forth, and therefore new players come up all the time. And then, yeah, consent authorization standards and requirements. I think that's also another fundamental point, because you do have this definition, of consent on the EU data protection laws, or even in the CCPA, you do have this definition of consent, which is there, and I think it's something fundamental for, for privacy professionals to be aware about. Looking as well at different data collection standards and requirements across jurisdiction. Again, by way of example, CCPA, GDPR, looking at other US state privacy laws. Lindsay talked about that earlier as well, so I'm not going to, to go further into detail on that. Whenever you have data collection, it does entail that the privacy rights are triggered in relation to such data. So I think it's fundamental as well to know about the different privacy rights which are around. Some of them are quite common across jurisdictions, some of them which are a bit less common. For example, the right to opt out of the selling or sharing of personal information. That's a little bit less common because you don't see it around the world. But then, the rights to know, the rights to delete and so forth, those are quite, or at least increasingly common around the world. 3.9 was intended to be more illustrative as to what can happen if you have an improper collection, because there have been in the past enforcement actions taken by the US FTC. So I think it could be interesting to mention it somewhere. Maybe not necessarily a full section dedicated to it, but then at least to provide some to provide some background on that. And then the categories of data, of course. What are the categories of data which are commonly collected? I think it's important to have some understanding of it. Here we only listed some examples, so these are not intended to be an exhaustive list. Of course, even in the text of the CCPA, you have more examples, but then I think those are these categories here are important because these are receiving more and more scrutiny from from regulators. Identifiers, what does it mean? Moving away from this concept of PII, but then we do have IP addresses and so forth, which are mentioned in identifiers. And then the digital footprint, online usage information, internet activity, that is also something which is explicitly listed as a category of information under the CCPA. Biometric information, that's, it could be interesting to refer here to other state privacy laws, for example, BIPA, where there is lots of litigation as well in that respect. Inferences, what does it mean to be making inferences, to be making a profile based on based on what the individual is doing or based on the information collected. And then data receiving special protection as well, financial data, of course, student data, information in relation to children. Do you need specific consent in some cases? health data, and then in this concept of sensitive personal information under the CCPA. And that's all I wanted to mention for this slide. I wanted to move on to the next slide, but then before we do that, are there any questions or comments?
If we were to kind of summarize the concepts, I guess the principles that are showing up under data collection, you know, could I you know, suggest is notice and consent. Those would be kind of the high level principles that I'm seeing here.
Yes.
And I think the question about consent could show up in the later sections, maybe in data use. Or data sharing. So I think it would be helpful to kind of, again, keep in mind what Paul is presenting here, and then we'll see what the later presenters say and how those two sections overlap. Okay, you have another slide for us?
Yes, just very quickly, the concept of data brokers, you know, which is mentioned in the CCPA, the Delete Act, and so forth. Therefore, you know, understanding the registration requirements which exist under California law and the disclosure requirements. I didn't go too much into detail in relation to the Delete Act, but then it may be something which you know, we may want to do. And then, you know, this concept as well of targeted behavioral advertising and marketing, you know, which is prevalent in the CCPA and also in other state privacy laws. You know, what does it mean to be conducting targeted advertising or behavioral advertising? Because it is something which, you know, more and more organizations are doing these days.
So again, can I just, you know, make sure that we're clear, because this is the data collection section, and we're not talking about conducting targeted and behavior advertising. We're talking about the data that's been collected to conduct targeted advertising, right? So we're really kind of thinking about the source.
Yes.
And maybe, and could I suggest that the way that we think about data collection is maybe first-party data versus third-party data. I think you allude to that a little bit in the data brokers, and I think in the previous slide in terms of the collection from third parties. But you know, could we maybe kind of summarize to say what are the notice and consent and data use restrictions that apply to the businesses that are directly collecting from the consumers, versus what are the obligations in terms of notice and consent and use restrictions that apply to the third parties who do not have, you know, direct relationship with the consumers? Because I think those are two different types of entities, right? Those with first party data versus the others that are more in the downstream.
Yes. So, you know, like you said, we could actually have moved this to the, you know, the categories of third parties. It's just that, you know, when we were working on these slides, we were, you know, I was thinking that if we do have, you know, too many sub bullets and so forth, then it does, you know, muddy things a bit, and that's why it was moved to a separate section. But then I agree with you, it doesn't necessarily have to be here. It would be more a subsection or subcategory.
And then again, I'm curious to see, you know, when we start talking about data sharing and data use, you know, whether there is a discussion about targeted advertising and a discussion about their data brokers, and whether it falls under here in terms of data collection, or if it, you know, falls under data use and data sharing. So we'll see. I think we're looking forward to the next presentations. Does anyone have questions for Paul? Thank you so much for your work and research on this, Paul. You know, data collection obviously starts the journey for the data lifecycle, as we talked about. So this was a fantastic way to kick off the privacy principles discussion and some of the operational challenges that privacy specialists face. If there is no question or comments for Paul, then Soyeon is next.
Hi, good morning. Okay, so emerging technologies. Just to give the overview on this approach is we definitely had kept in mind the purpose of conducting this research. In other words, it is to provide guidance on how to approach emerging technologies in exam questions, and that includes as an exam topic, but then also how emerging technologies are, how they affect both our clients and then also attorneys. And there was amazing, obviously robust overlap with, for example, professional responsibility and data collection, and then all the principles that Lindsay provided in her chart. Because obviously, it's not necessarily a new analysis, but it's how to provide an analysis on new technology. And so one of the most salient features of emerging technology is that we're all just a consumer of the small place on earth that we occupy. In other words, when we talk about emerging technologies, it's very broadly defined and can be quite disparate depending on the industry. Even though, for example, artificial intelligence is sort of top of mind for everybody, it really is mainly there because it's a huge feature in consumer products. But if you were going to look at more obscure products and services that are offered by our clients, then there are emerging technologies that don't reach that level of zeitgeist. So when we're testing, one of the fairness factors is that, for example, Ryan and I had this very interesting discussion about, developers in HIPAA, which he is an expert, that is his domain. And then we're talking about developments in, recent FinCEN requirements and laws, in which case, other practitioners might not be aware of that. But on the other hand, if someone who specializes in FinCEN or corporate or, securities, is also going to sit for this exam to be a privacy specialist, we can't neglect them for other emerging technologies that might be more popular. Those are in quotations. So part of any analysis or any exam questions that would include emerging technologies would be the robust amount of establishing exactly the context of the emerging technology, and that would be the client role. And as we discussed earlier, to determine, where they are in the stream, and then also determine, whether they're collecting data or they're distributing personal information or, et cetera, et cetera. And then to develop a map of exactly what sort of transparency they need to provide or request, and then also the consents that perhaps would be required. And that's just, by way of example. So, and then of course, the methodology would be then to reference the specific regulations that would apply to their clients or the industry. And so, the first three are really to frame it for a test taker in order to establish how they would tackle emerging technology. It's going to be new, and we need to, as practitioners, need to know how to pivot, communicate with our clients, and then develop a strategy in order to protect our clients and then also protect the public at large and make sure that we're in compliance in order to do that. So the 4.4 is really a special note, because when we do, if we are going to test on emerging technology, I mean, the test is arguably for competence, and so it would be paradoxical to require practitioners to have competence in an area that's still emerging. So for that reason, that's why if any questions are too new, I'm not really familiar with how exactly, like, legal questions on an exam that are too new, but I think everybody can get the gist of it. If you're an emerging technology, it's cutting edge, it's not going to be settled. Yeah, in case law, there might not even be probably won't be regulation or agency guidance. But I do think that, especially, the further we move into technology or just the embracing of technology, then the mindset will be more plastic in terms of requiring practitioners to tackle these novel issues. But anyways, in the interest of fairness, it can't be too new because that defeats the purpose of a test for competence. Okay, and then 4.5 is really about the platforms, so to speak, apps, devices for commercialization, health tech and wearables, financial tools, digital currency, QR codes, autonomous vehicles, social platforms, very broadly, and there probably could be more, but these are sort of like the delivery or methods to provide interface or commercialization or services or products. And then the technology is in 4.6 is specifically, and it's not an exhaustive list, the Internet of Things, artificial intelligence, virtual reality, augmented reality, et cetera, et
The
cetera.
next page, please.
Oh yeah,
Dana.
sorry. And the next
Right.
page. And it's not necessarily to, have a division between how products and services are delivered versus the technology implemented, but it kind of goes to the analysis and the depth and breadth of new technology. And then also in conducting the research, I mean, it was super broad. I basically followed the path of every article or publication or press release regarding to emerging technology or new technology and privacy. And, it went from the White House to farm equipment, and so one of the interesting aspects is how you might have, for example, for the service platforms, QR codes is on this list because it's just, it went away a little bit and it came back, and people are taking something, they're implementing it in a different way, and then revising it in many different implementation. They can implement it in different ways, and so therefore you might have not an established technology but a familiar technology that's implemented in a novel or new way. So there's just so much that was distilled into these two slides. But basically, to recap, there is the technology itself. There's also the analysis of, the client's role. And then there's also the issue of the fairness of testing on emerging technology. And then, of course, wrapped up into this as well is the attorneys or law offices or the law practices implementation of emerging technology. And, I was tempted to separate it, but at the end of the day, if you're a legal professional who implements emerging technology, then it comes back to, placing our role as a consumer, in which case it would be, 4.1, 4.2, and 4.3, because then we would have, and of course, an added layer to that would be to 4.3 as research existing regulatory agencies and laws, which would be state bar, any rules of professional responsibility, et cetera, et cetera. Anyways, any questions?
Yeah, thank you. Adrian?
I just wanted to, I heard you mention competence when you're describing these, but when we describe the legal specialist exam, we're testing for proficiency. I just didn't know.
Oh, okay.
I didn't know if you're using those interchangeably at all, but
yes,
yeah,
you are right. Proficiency.
yeah, we're testing a little bit above like minimum competence. So
Got it.
Thank you.
Thank you. Thank you so much, Soyan. This is really fantastic research. As you said, this is probably one of the most kind of nebulous part of our presentation, right? Because obviously emerging technology by definition is emerging. And so this is going to continue to evolve. And so I think our task is to, again, kind of give as much research and presentation and information to the state bar to understand this is why a privacy law specialization is needed, right? Is that in all of these 12 different new technology topics that you have highlighted here, the privacy laws are evolving, that they are coming, and that a privacy law specialist would need to be proficient in these laws. Having said that, Soyeon, I think you bring up a really good point in that earlier slide. To what extent should we expect that there is proficiency in all of these laws? If I am an everyday practitioner and I'm not an expert, let's say, in brain-computer interfaces, and for those of us that are paying attention, Colorado just passed a law about neural tech and brain data, and California is, looking into that too. So this is absolutely cutting edge, but maybe I'm not an expert in it. So to what extent should a privacy law specialist exam test proficiency on these particular emerging technology? So I think that's a really good question. So you're presenting to the group, and again, that push and pull. How granular do we get, and also test on a certain baseline level of proficiency. An administrative question, back to the state bar, to kind of highlight what Soyeon is presenting. We are at the point of, I think, highlighting for the state bar to consider and to make a recommendation. One, that privacy law specialization is needed. And I think Soyeon and everyone else here is really making a strong case for that. Because of this proliferation of legal issues and how fast this field is changing. Setting that aside, we as the consulting group, we don't have to make the decision today. That is not part of our tasking to decide how the exams are going to be drafted, right? Once we put together the high level topics and say, these are the kinds of topics that the exam specifications should include, then the exam writers, which we are not at that point right now, we are not the exam writers. The exam writers will have the judgment and the discretion, I think, that Soyeon is looking for in terms of saying, hey, is that too new to test on the latest Colorado law on neural data? And so I would say that judgment and discretion is really kind of applied at the exam writing session, not at the level that we are at, which is setting the exam specifications. Did I get that right?
Yes, I think all of that sounds correct. So
Thank you.
yeah, right now the focus is on the content.
Okay. So then I'm going to ask a kind of a similar question to Soyeon that we did for Paul. What level of specificity were you thinking for the emerging technology exam specifications? Were you listing, for example, these 12 new technologies, as an illustration of all the different, new technologies that potentially would have privacy consequences, and therefore you're saying an emerging technology should be a topic that is on the exam? Or are you thinking that specifically these 12 should be listed? So, is it illustrative, or are you thinking that these are so important that they should be actually spelled out in the exam specs?
Yeah, I think the dual purpose is, number one, when we're testing for privacy proficiency, one interesting aspect is that even though these are just disparate, the analysis is pretty consistent in terms of what has been presented before about data collection, right? I mean, even if we have a really new technology, we can say, okay, this is how I'm going to map out the privacy analysis. So on the one hand, that's something that's the methodology, the approach is something that could be, that we would need to have that we could test for proficiency, the approach. So the dual purpose of the 4.6 is, number one, to show the breadth, because we are so excited about, artificial intelligence. But then again, when you look at, decentralized technologies for, mapping out security for a city, for example, which I forgot about, or genomic testing or brain mapping, as you mentioned, it really hammers home the point that this is not one monolithic area. And so if you if you settle into saying, oh, I put a bunch of questions about the Internet of Things, I'm set, that's not going to be sufficient, because the Internet of Things is not comprehensive enough. It doesn't represent new technology. And I included that because I don't know if it's me or if we're like all used to it, but that doesn't really feel like emerging technology right now. I think because we're all based in California, we're just used to hearing that. So yeah, I wouldn't say that we would have to test on 1 through 12, but I think what would be a good approach is maybe to see which one. I mean, if you were going to be a test writer and look at this list and say, okay, I get it, there are too many to drill down on, but I can choose the ones that are maybe a little bit more established, maybe artificial intelligence, that were more, or virtual reality. But not really being a test writer myself, I don't know how that would like factor into how a test question is written. But my point is, it's a sampling, but it's also a reminder of how broad the field is.
Yeah, I think that's exactly right. Question for you, Adrian and Amy. To the extent that this is a rapidly evolving field, and I think that's why, such a specialist, certification program is needed. Is there any opportunity for the state bar, as we're kind of thinking this through, how to roll this out? Let's say we left the topic, exam specs said emerging technology, right? Let's say we leave it, very broad, because we don't want to list these 12 things. It's going to be 24 things, by next year, right? So let's say we recommend that the privacy law specialist exam should include some testing of new privacy laws to the extent that they have specific applications on emerging technologies. Moving forward, let's say an exam is announced on Gen 1. Could the state bar say that just, changes with the time? Would we be able to say, the exam that's rolling out on Gen 1 will include the latest biometric law, will include the latest neural tech law, give some kind of guidance to the applicants that, certain XYZ latest law will be in scope? Is that something that the state bar can do?
Yeah. So ideally with any exam, what you would do is lay out the scope. So exactly like what this map would be. So people, any candidates, potential candidates could know what areas they need to study for.
I see.
And then as developers, who wear a different role, they take the content map and design questions around that. They would need to also make sure that this stays updated, because I think that's part of the concern here too, is that the technology is emerging, it needs revision, or at least consistent review. So I think that is what the task would be for those that are developing the exam. Even pre-testing, that when you pre-test questions, that there is that the concepts are still valid, that the law is still accurate. And so that's a different role. But yes, I think the idea here is to alert people that is part of the requirement for this area. And then and knowing that it would be evaluated before and after each exam.
That's perfect. So what you were telling us, again, to make us feel better about our tasking, to clarify our scope, we don't have to say these are the 12 things that are going to be testing under emerging technology. That is going to be in the development of the exam, and will be announced, if and when this exam is announced in terms of the actual scope, meaning that would allow for the innovations, right, and the changes in the law.
Correct. You're specifying that is a part of the criteria under new technology. And then the next group would, they're tasked with determining what gets included in that area.
Perfect.
Okay.
That is really helpful. Any other questions or comments for Soyan? So I know that there is, in terms of your, comment, Soyan, about, AI, I know that that was also, you, as correctly pointed out, Mariah talked about, AI and some of the ethical, obligations as individual, specialists, if you are using AI in the legal practice, which is different than, again, kind of the business obligations and the legal counsel for businesses that are using AI. So again, I think emerging technology is one of those topics that we're going to see a couple more times. The next topic is on data use. And I'm looking at the clock and we're at noon now. I don't think Hillary is on at this moment, right? So we'll go ahead and take 30 minutes. I feel like this is a good time to stop. And we'll stop the recording. We'll come back at 12:30 and we'll begin with the data use discussion. Does that work for everyone?
Yes, thank you.
Okay. Thank you, Janelle. If you could go ahead and stop the recording, please. Okay. Thank you very much. And we're going to start next with Janelle, if you can begin with slide 27, I believe. The discussion is on data use, and Hillary and I prepared this portion, and Hillary was not able to present, so I'll be presenting. And I would say that the lively discussions that we've had in the earlier part of the open session, I think we're going to really be benefiting from it. And so hopefully the next several presentations will. If everyone could mute themselves, could go a little bit faster. So as we talked about, I think the data use section is something that I know, at least 3 other sections we have looked to see if there are ways of overlapping and whether certain presentations and legal issues should fall under data use or not. So, not having had the benefit of the other presentations, this is what Hillary and I proposed for data use. So we focused on what are the legal issues that the exam for privacy specialists could test. And we thought about the different kinds of uses and decided to talk about the laws that would regulate the uses of data. So the first use of data that we thought would be helpful to talk about in terms of privacy specialist proficiency is de-identified data use. And maybe this is the absence of privacy implications. The fact that there are laws that identify and spell out what does it mean to have de-identified data, and to take certain data out of scope for privacy laws. And so although it sounds counterintuitive, we thought that it was helpful to talk about some of the privacy standards that would apply to keep certain data out of scope for privacy laws, as that is one of the tools that the privacy specialists use. Again, in terms of talking about the level of detail that we will want the exam specification to have, I think our thinking was that we would keep it at the first level down. So the 5 is the topic, use of personal information, and we are putting forward the 5.1 to 5.5, I believe. There are 5 topics, I believe, and the rest, the 5.1.1, etc., those are for illustration purposes only. So to the extent that we're thinking about CCPA, we're talking about GDPR. Again, those are for discussion purposes. That's what we're thinking. We're thinking that the de-identification, aggregation, and pseudonymization standards under CCPA and GDPR, for example, are what we are thinking about when we are talking about use of data that's been de-identified. Clearly, we can use HIPAA. I know that we talked about industry-specific laws. There is a HIPAA de-identification standard. This list can be much longer. So, we would propose to keep the exam specification at the de-identification level, and whether certain data is confidential whether, you know, certain data is defined to be de-identified under CCPA, GDPR, HIPAA, et cetera, would not be on the exam specifications, but this is what we're thinking about. Second use that we wanted to present is the sale of personal data. And I think this is, again, we are looking at and we are cognizant of the fact that this could be dealt with in the sharing, data sharing section, which is coming a few sessions later. I'm just looking at the order. So there is a separate section on data sharing, but to the extent that the data sharing group does not talk about the sale, we wanted to make sure that it is part of the exam specification. So the sale of personal data was one type of data use that we thought should rise to the level of being included in the exam. The use of data for targeted advertising purposes and everything that goes with in all of the different examples, in this, how it's defined under CCPA, how it's regulated under GDPR, et cetera. So again, you know, the list continues, but in general, the use of data for targeted advertising, we thought is one of those, I think, legal concepts that are requiring proficiency by the privacy specialists at the moment. And so we thought it warranted a separate discussion under the data use. Let me stop there and see if you have any questions or comments. If not, we'll go to 5.4.
I do see Adrian's hand raised.
Okay.
You know, sorry, I don't know if it was mentioned before, but I guess in terms of the level of detail, so we do share this with the developers and the applicants. So I think if it's something that you want to call out specifically for the developers and the applicants, I think you can leave it. Something to compare it to. So looking at the first year exam content maps, they list through 4 levels. And then they also provide a statement that says the outline is not intended to list every aspect of a topic mentioned. So we can do that. And then even at one of their list levels, they say like including termination of offer or including irrevocable offer. So we can, that's always an option as well. So I don't
Got
want
it.
you to feel like you're limiting yourself or anything. So
Got it.
just something to
Meaning the
consider.
content map could go to, you know, more than just the 2 levels down. And you know, we could add because I think as you can see, right, Amy and Adrian, you're hearing from many of us that, you know, we're hesitant to say, you know, this is it, because the laws are constantly changing, and privacy is one of those areas that is just so very dynamic. And so I think you're hearing a lot of hesitation on us. So I think we are trying to put as much detail into this to show this is an area that needs to be tested, and this is an area that requires proficiency from a privacy law specialist, but we don't want this to be limiting. You know, we don't want this to be, you know, quickly out of date. We hear you. We hear you on making sure that the exam specifications provide enough data, enough information in the content map. I saw Lindsay and Mariah. I don't know who is first.
Lindsay was first.
Lindsay, okay.
Thanks. I think your 5.1 is a really, it's almost like a gating question about what is personal information. So I'm not sure where that should live. I'm glad to see it here. And I think we discussed it in the collection in terms of the data elements, maybe key data elements. But this is a different spin on it, right? What does it mean to be out of scope? So I just bring that up for, you know, the thought about where it should live in the whole content map here.
Yeah, I agree. We had that conversation with Hillary. You know, we were talking about like, well, you know, this is something that we could talk about in the collection section, for example, right? Or in the notice provision, you know. So I think this could live in a couple of different places. But to the extent that it was not, you know, dealt with, we thought we would put it in here, you know, in terms of the use. And so the use of confidential information and business information, I think the discussion that we want to have is to maybe for the group to weigh in on is, to the extent that this is meant to be a privacy law specialist requirement, would we, let's say, for example, I think some of us do trade secret protection work, right? I think some of the privacy law or, privacy officers, my former job as a chief privacy officer did include protection of confidential information and business information and trade secrets. And so do we think, this is a gating question, as Lindsay is saying, do we think that our certification should include protection of non-personal data that would include confidential information and business information and trade secrets? Or should we deal with it only to the extent that, we are mentioning that this is out of scope for privacy laws? I don't know if people have thoughts about that. And then Mariah, I know that you have a question. I don't know if you have
I have a similar
comments on this
gating.
or on a different question.
As to the question as to whether or not we should be focused exclusively on the collection and use of personal information, I don't think we should. I think we should include confidential and other business information, at least at a high level. I had another gating scope type question, which was, now that I'm looking at this, and I see that you've identified, obviously, some emerging privacy laws in China, Australia, MENA, et cetera. I wonder if we need to also have some additional scoping question around, like, I know that we're global, or I believe from our last call that we decided to be somewhat global. But how do we address that, right? Are applicants really going to be responsible for knowing the ins and outs of the new China privacy law? I don't think that's reasonable. It looks here like we're including it only on a topical basis, which I guess makes sense to me, but I do think we have some sort of high-level gating and scope issues that remain outstanding.
I agree. And I think that's why, I was proposing that the exam specifications are at the higher level, right? So we would say there is some type of personal data used for targeted advertising. There are some laws that regulate how data is used for targeted advertising, and the exam should test on the legal knowledge related to the use of data for targeted advertising purposes. That's where I would have left it. I think I'm hearing from both Adrian and Amy that you, from a state bar's perspective, you will want a little bit more detail. I think I'm hearing from you, and please correct me if I'm wrong, that you don't want us to remove, the fact that we're calling out CCPA in the definition of sharing, for example, or the Chinese privacy law. So I think that's kind of where we would want to have a group discussion about this. Ryan, did you have thoughts about this or a different topic?
It's kind of both.
Okay.
I think with regard to the international privacy laws, I think a lot of that can be addressed with sort of at the principal level, because you're right, it's going to be impossible to track all of that and as it moves and changes and evolves over time with the different countries. But I think a lot of those principles are very universal. And when we were doing our research, we saw some of that, and I think we found some stuff out of Australia, and we're like, oh, okay, that's an interesting concept. And then as far as the de-identification of, that can make some information outside of the scope of a privacy law, if it's no longer PHI, you can get out of the HIPAA world that way. But I think a privacy practitioner really needs to be well-versed in what de-identification kind of is and what anonymization is. And so they can recognize when HIPAA is not going to apply because it has been appropriately de-identified. So I do think that some of that confidential information or information that's been de-identified, we want to at least touch on it.
And not only just touch on it, but I think what I heard from Mariah is that we should actively include as a scope of what a privacy law specialist does, that a privacy lawyer is not just in the job of protecting personal data, but that a privacy lawyer's job could include protecting non-personal data, let's say confidential information or trade secrets. Did I get that right, Mariah?
That's correct. And only at the high level. I don't necessarily think we need to go into the same level of detail about CBI as we will about PII, but I think we need to acknowledge.
And one of the last section is the intersection, right? So that could be another area where we could say, hey, to the extent that there's a body of law that is focused on personal data or personally identifiable data, there is also another body of law, and maybe that's not the focus of this certification, but we will acknowledge, right, that there are some obligations and duties that the privacy law specialist should be aware of for protecting non-personal data.
A lot of
And
times,
how to get to it, which is your point, Ryan, right? Is that sometimes I think the privacy lawyer's job is to minimize the data or to apply certain privacy enhancing technologies to render the personal data to be de-identified and out of scope for privacy laws.
yeah, and a lot of times, that confidential information section of an agreement that we're working on, it'll touch on information that's sensitive to the organization, like financial information that may not be PI in the traditional sense.
Mm-hmm. All right. So if there are no other questions or comments, let's go to 5.4.
I have one additional comment, and it's
Sure.
only, and candidly, I'm remembering it now because of our discussion about de-identified and aggregation, but it pertains to the last slide deck before lunch, which is privacy enhancing technologies and privacy preserving technologies is maybe an area that we should include in the emerging tech section. Just a comment to get out of the way.
The role of the PETs, or are we talking about are you talking about specific laws that have to do with PET regulation?
I think the obligation to consider pets and other privacy enhancing processes as one solution to addressing privacy might be interesting.
Mm-hmm.
Or mitigating privacy risk, really.
Yeah. To the extent that there are laws that say, right, that you should engage or you should think about, I mean, there's a lot of, I agree with you. I think there's a lot of laws that are saying, a third party audit is required, a third party age assurance, is required, et cetera. So to the extent that those kinds of, third party engagement is being required by law, I think that would be an interesting topic. Let's go to 5.4. So again, continuing, we thought about these 5 uses and the laws that would regulate these types of uses. And so 5.4, we want to highlight 9 different business purposes that would be regulated by privacy laws. And you see here, HR employee, which was one of the topics that came up in terms of notice. And so, these are the business purposes that we thought, again, give rise to some legal obligation for the protection of personal data or confidential information data. So we wanted to, these are the business purposes that we thought about and how to talk about the legal obligations that the privacy specialist should be aware of. Number 5 is the last use that we thought about and the laws that regulate the use related to compliance with the law. And so again, these are the 3 examples that we came up with. Public records requests, law enforcement, or data sharing with government agencies. And we have questions here because we were wondering if these 3, because the compliance with law usually is a type of use that we see, that's disclosed in the notice, that collection that we talked about, but we weren't sure if the data sharing section was going to take these topics and really kind of own it, or if it's going to be here in the data use, because we felt like this was really a sharing use, right? It's about how public records are shared or how data is shared with law enforcement or shared with government agencies. And so we could see these 3 topics being owned in the sharing section rather than in the use section. Having said that, I think the public records, the use of public records is something that is a topic of concern. And so I don't think this is simply just a data sharing question. I think it does deserve some discussion in terms of the use of public records. And, you could probably say the same thing on the law enforcement data or government agency data too. So it's the use, but also the sharing with these agencies. Any questions there? Okay, then let's go to the next section. And next section is going to be about data security. And Michael is going to discuss for us the research and the proposed exam specifications for data security.
Thank you for that. Hi everyone. So this section handles about data security. So how I tackle or handle this was to specifically look at the cybersecurity standards from different certifications and testing areas and pulling from my past experience of when I was licensed in cybersecurity before law school. And so it's interesting because it's hard to really extrapolate and then we contextualize that for a data privacy only subset. But these are the main principles or areas that I thought might be relevant from a data security perspective, looking onto a data privacy, especially one for data privacy that specializes in a legal or attorney license. So I hope that helps contextualize what these principles and standards are. I can go on and on about cybersecurity, and if you want to know more, I actually found out that my legal article on legal cybersecurity was published for the ABA litigation section earlier this month, and that's 12 pages, meaning it's a 12 pages mini guide for that. But with that said, let's focus on what I highlighted. And I noted that Lindsay and Paul, I did address some of their concerns or what they brought up. So I will highlight that as I go along. The first one is data security principles, and it's more about understanding confidentiality, integrity, and availability, or the CI triad. Usually they also include authentication and authorization in part of a data security field. However, that's more in the contextualize of personal data protection. Next one is more about how these principles pertain to personal data and data privacy, and then securing the data lifecycle management, including the collection, processing, retention, and deletion, which I will note that that's what Lindsay brought up previously, and what we discussed a little bit about the data lifecycle. Like I say, data security, how I approach it is more of a practical standard, not necessarily a legal context, but more if you're a cybersecurity professional. So that's why there's some repeats, if you want to frame it that way. Next one is encryption and anonymization. It's a use of encryption to protect data at rest and in transit. So those different principles of when you collect it and store it compared to how you transport it through devices, browsers, other like how Soren puts it, autonomous vehicles as well. That's something in which it's interesting to secure the transportation and the tunneling protocols for that data and what type of data is being collected. Another principle is anonymization and pseudo-anonymization techniques. That reduces privacy risks. It could, as I noted, also include legal implications and effectiveness. Next one for 6.3, it's more about accessing control and identity management. So about more robust of who can control and access the data. And more specifically, I think I more or less approach it as in the cybersecurity professional, like the head, one of the heads of a person reporting to the CIOs of just being able to manipulate and control the data. I know the multi-factor authentication, which is more on the user end, while role-based access controls, or BAC, is more on the organizations who controls the data, what roles they have access to, and setting the privileges and privacy and administration levels accordingly. You can go to the next slide, please. Of course, is there any questions on those two? I have quite a bit of slides, so I don't want to interlude. So, were there any questions on the previous slide?
Yeah, just to let everyone know, we have 10 here, 10 topics under data security. So unless we have kind of a burning question, maybe we'll let Michael, do the presentation for the 10.
Thank you for that. And probably it's 9 because the last one is emerging technologies, which Shorin eloquently put. 6.4 is more about, again, it might be a little repeat, but it's slightly different, but different methodologies for a cybersecurity professional. It's about securing the practices for the data collection, processing, storage, and destruction of the data. And it's to check that data throughout its entire life cycle. So not only the legal implication, but the security standards, and then the actual rules settings. I guess not white papers, I'm blanking on it, but more about the actual procedures and protocols of controlling that data. And then of course I throw in the legal consideration of that. Next one is security audits and compliance assessments, which is very similar, if not what we discussed with Lindsay about risk assessments. It's more about conducting security audits and assessments to evaluate compliance with privacy laws and industry standards. That's to drill down more is about looking at and understanding the regulatory frameworks requiring a specific security measures. I put down PCI DSS for payment data. For people who don't know that, that's the payment card industry data security standards, so credit cards more or less. And then you look at the network and application security for that, and you oversee and conduct risk analysis or risk assessments of what security standards you want to implement, how costly it is, how burdensome it is on the systems, frameworks, user experience, the friction of that for user experience as well. And then you look at security measures for protecting networks and applications from threats, including firewalls, anti-malware tools, and application security testing. That also includes DDoS, so distributed denial of service attacks, man-in-the-middle attacks. I didn't put down social engineering attacks, but that can be included as well. Those are a little bit different, but those are just hijacking accounts and passwords through the manipulation of human personnel. And then the last one is implication of software vulnerabilities on data privacy and legal responsibilities for securing applications. So that more entails or encapsulates patching, making sure you have legit licenses of software and what you use, understanding the limitations, any disclosures of vulnerabilities, and how to combat that. As you probably know of, but haven't really gone too deep into, is cybersecurity professionals' understanding. You have zero-day exploits, or few days after the zero-day exploits, of what to do, how to handle it, how to minimize, do you have to remove systems, to make sure the data is secure, it's safe. What are the protocols? Do you have to roll back? If you roll back, will that create disruptions in the services you control? Like I said, there's a lot of interesting nuggets for that. Again, trying to extrapolate that and only presenting it in a data privacy legal lawyers context. You can go to the next slide, please. Again, this is a little redundant, but it's also just highlighting cybersecurity viewpoints as well. We look at incident response and data breach management. So the legal requirements and best practices for incident response. You have to know what are your plans, how you can execute them, who needs to be notified, how can you make the public release statements if you need to do that. understanding what happened is the main issue as well, how to secure it. And then in the cybersecurity context, how can you prevent that, stop it if it's ongoing, make sure that it won't happen again, won't make sure that the exploit is eliminated, and then understanding what tampering has been done or what siphoning has been done. There's a lot of into it, and you have to look at data logs for that and other stuff.
And just to just jump in before you continue with the second half of this is that Michael, I think what we discussed as we were preparing this is that of course, there are many certification programs just for data security, right? And so we do not intend the privacy law specialization to be a data security test. It is not meant to test, whether a privacy lawyer is proficient to become a cybersecurity professional. I think the background and the research that Michael is presenting is really helpful to the extent that a privacy lawyer should have some minimal, baseline understanding of, what does it mean to be a good legal partner in incident response. And more specifically, I think what we were thinking of is for this to test the legal requirements related to each of these topics, right? So if there is a law that says that incident response and data breach management should be done this way, if there is a specific law that spells out that a security awareness and training is required, that's what the privacy law specialist test exam would include. It would talk about the legal obligations in each of these, not how to do security awareness testing, right? Not how to do data breach. I think that's really an important, distinction to make.
Definitely. Thank you for that eloquently quoted. I really will emphasize that Lindsay's slides and her research will help supplement my information. I looked at them on a security practical standpoints of data usage and security. The issue is usually the laws that I understand don't really highlight what procedures or practices needs to be implemented. It's more of a general overbroad view of encouraging best industry practices because that's continuously changing, especially with some of interesting zero-day exploits. Not going into too much, but we had eons ago, which is 8 years, I believe, around. We had the Spectra and Meltdown speculation attacks, which, to really briefly summarize that in 1 or 2 sentences, it's the theoretical output of can you do CPU manipulation of knowing what cannot be done through speculative CPU analysis. If you know what cannot be done, you know what can be done if you look at it as a 0 and 1 outputs. So it's a yes and no response or binary. If you know what can't be done, then in theory, you know what can be done with some probability. The reason for that is that's why the CPUs back then are no longer applicable.
I'm sorry, Michael, could I just interrupt?
I'll go on.
I love hearing about the case studies and all of the extensive knowledge that you have, but could we continue with the exam specifications?
6 was just highlighting those types of errors can't be tested. 6.7 security awareness and training. Again, that actually highlights to what I was saying. You have to have probably ongoing licensing or renewal if we want to do that for the data privacy. I'm not sure if that's something we're exploring, if it's a one-off or if it's continued licensing and continued education. 6.8 is physical security and environmental controls. Again, that's more about understanding the infrastructure and all that stuff, the security measurements. Probably if we want to encapsulate that, we look at it into setting up the incident response and data breach management, as well as understanding who is in control and have risk analysis outline. I guess the bare minimum is understanding and knowing you need procedures and how to establish those procedures, and then of course implementing them when needed. 6.9 is more about ongoing. This is not a throwaway, but it's does a catch-all on ongoing government policy that the other people have highlighted, like Lindsay and Paul. And then the last one, if you go to the next slide, is this is 6.10 catch-all, because data security is, of course, with all emerging technology trends, and Soren eloquently covered that. Here's some extra stuff, but Soren covered much more. And then it's more about privacy by design compared to privacy by default in terms of how these technologies are implemented. Some technologies require different ways of securing because it's by design rather than by default, and all that. Any other questions?
Thank you so much, Michael. Again, your research and the presentation on this is so very helpful for this consulting group. And again, the emerging technology, as you can see, is one of those intersection areas. And we've talked about this a lot, and it's going to come up again at the end of the next couple of slides. So I think what we were thinking is that this would again be a focus on what laws. So are there data security requirements by law that would be specific to emerging technologies? So to the extent that there is an AI security requirement that a privacy lawyer specialist should be proficient on, we thought would fall under 610.
And if we want, I'll just highlight quickly my previous example about spectrum meltdown. That was 8 years ago, and the theory of CPU future or speculative predicting. The reason why that was relevant is today we have much better systems and computers, and we have AI-ish, I won't say true AI, programs that can actually make spectrum meltdowns of 8 years ago a reality today. So that's why emerging technology and principles and understanding and new ways of doing things is very relevant in understanding how can we cover areas in which law, and this is probably my main focus, this is more practical standards or practical stuff that law may or may not be covering at the moment, but is relevant to understand or should be covering in the future.
I have a comment. Michael, thank you for your very comprehensive overview. When I, as a sort of data privacy practitioner, think about data security, one thing that I tend to look at is what the privacy laws require for businesses, right? So it's that idea of like reasonable security measures. And I think that I would expect to see some of that in here. So the CCPA's data breach provision could be something. And then New York Shield Act, right? It's not about getting into the practical standards, although I think they are very important and useful. I think for a privacy practitioner, it's about understanding the legal standards that have emerged in some of our privacy laws for data security practices, for what that's worth.
That's exactly right, Mariah. So when we were preparing this, Mike and I, we, instead of saying reasonable security, which is what most of the laws say, we wanted to kind of break it down into pieces, right? So if you kind of want to go back to the first slide, we talk about the principles that are going to be applied to testing whether there was reasonable security. So data security principles, that's one. And then, is there encryption? Is there access control? Is there lifecycle management? Are there audits? And so these 10 topics are what Michael has presented that kind of break down what a reasonable security program would look like. And for exam purposes, I think what we would propose is that we would test the legal requirements for each of these, right? Is there a law that says encryption is required? Encryption of data at rest versus encryption of data in transit. Is encryption now a legal standard? Is it not? To the extent that there is no affirmative requirement for encryption, let's say in transit or versus, encryption of data at rest, then a different way of talking about the legal obligations related to encryption is the fact that there's an encryption safe harbor. So if you have encrypted data, it would not, result in a data breach notification, right? So, whether there is an affirmative duty to apply these security principles or maybe the lack thereof, results in certain privacy violations. I think that's the way that we were thinking about and really kind of breaking down what does it mean to have reasonable security. We want to give a little bit more than just say have reasonable security.
And
That makes
like-
perfect sense to me, and thank you for that. I just wanted to clarify, it's all in furtherance of that higher standard. And
That's
that makes
correct.
sense.
Yeah,
Okay.
which is usually what the law says, right?
Exactly.
The laws are very nebulous, and I think
Mhm.
Michael has done a really good job in breaking it down into, 10 bite-sized pieces.
As I preface, I was looking more at the practical security standpoints because law itself is and like I say, Lindsay did a great job in outlining the other stuff. And like I was relying on other individuals and not seeing the bigger scope of everybody else. And understanding that, well, this is my nugget or contribution is, well, let's focus on the practical and see if I can break it down so we can allocate or slot it when the time comes, which is right now or in the future, to see what we can, oh, Lindsay has these laws, and let's see which category, what's the emphasis and focus should be.
Thanks very much, Michael. Any other questions for Michael on data security? If not, we'll go to Arsen for data sharing.
Great, thanks. So I think for these topics, what we try to do is address some common themes or issues we observe under US privacy laws related to data sharing. And so one module in which data sharing can arise is disclosure, making available personal information to service providers, contractors, which are the defined terms under the CCPA, and then processors, which is the synonymous term under the non-California privacy laws. So this 7.1 is intended to essentially test the understanding that you need certain contractual terms if you're disclosing information to a service provider, contractor, or processor. 7.2 is intended to address situations where personal information is disclosed or made available to other controllers or quote unquote third parties. And third parties is a term covered under the CCPA. The other states don't necessarily have a clearly defined controller to controller type of disclosure standards, but if a recipient is not otherwise a service provider or contractor or processor, they would likely be a controller in that scenario. And so this is intended to cover those scenarios. The 7.2.1 is related to data monetization. And for that, it relates to situations where personal information is sold. And this could arise in different scenarios that are otherwise covered later as well, which is data broker scenarios and sale of personal information. But there could also be other sort of co-op databases and other arrangements between controllers for how to monetize data. 7.3 relates to data sharing for targeted advertising, and this is intended to address the cross-context behavioral advertising and retargeting scenarios. And again, certain terms are needed in that scenario as well. But this would, cover a scenario where a third-party cookie, for example, is on a website or trackers, and it tracks users across businesses for targeted advertising where personal information is made available. And there's other scenarios common in the ad tech ecosystem. 7.4 addresses the situation about being transparent about your disclosure practices. California, for example, has the specific requirements and there is privacy policy for delineating the type of personal data that's disclosed to third parties, the commercial or business purpose for disclosure, and the categories of recipients. And the other non-California state laws have similar requirements. So 7.4 is intended to address that. 7.5 addresses consent, and this could come up in different scenarios. One is, if you're collecting sensitive data and need to collect or disclose it or other type of processing activities, The non-California states have an opt-in consent requirement for sensitive data. And consent also can come into play in California if you're relying on an exception to sale, which is intentional direction. So different scenarios in which consent can come into play with data sharing and disclosure. And so 7.5 covers that. 7.6 deals with right to opt out. So for example, if you're selling or sharing information or using information for targeted advertising, California and the other states have opt-out requirements. And so this would test the candidate's knowledge on that issue. 7.7, again, sort of tying to 7.5, there are certain consent requirements and disclosure requirements related to processing of sensitive data, including, if it's processing activity, which is broad enough to include data sharing. And so that would test the candidate's knowledge about the SPI issues. 7.8, data brokers are obligated to register if they're selling information. And so this would test the candidate's knowledge on that topic regarding the scenarios in which you do have to register and other obligations of a data broker. And then finally, 7.9 will address cross-border data transfer issues. While this is not necessarily codified under US laws, it is still important for a US exam because if you're a recipient of personal information from an EU, UK entity or other regulated jurisdictions with data localization laws like China's PIPL, then you have to have some knowledge of these requirements as a recipient of the data in the US.
Okay. Any questions or comments for Arsen?
My only comment is that you might want to consider data sharing with like government agencies, law enforcement requests, FISA, et cetera, as a subtopic.
Yeah, I was wondering that. So, we discussed that in the earlier, right, in the data use section, and I see that it's not in the data sharing. So it would be a question for you, Arsen. Are you okay with the sharing of data to government agencies, law enforcement, public records requests, et cetera, being under data use, or do you think it belongs in the data sharing section?
I think it could go either place, and I don't have particularly strong feelings either way, so we could put it here as well, maybe just to cover our bases.
Mm-hmm. Yeah, Mariah, do you have a strong preference on where it sits?
It's
right
not
now, it's under data use.
It's not a preference per se. To me, conceptually, I view it more under data sharing because it's a category of person or entity with whom information is shared or maybe subject to sharing. So I view it more that way, but I don't have a strong preference.
Yeah. Yeah, I think so too. That's what I was thinking, when we were doing the data use, discussion, is that this probably fits more on the data sharing, but it's really about how the data is used, right? And part of the use is sharing. So it is all related. But I think what you are pointing out, Mariah, and thank you, Arsen, for your research and presentation on this. And clearly, this is the section that, I feel like intersects with pretty much every other section that we've talked about. So thank you for doing such a succinct job, Arsen, in encapsulating the top, topics here. Mariah, maybe what you are pointing out is, without saying so, but let me see if I can, kind of restate it, is that I think on data sharing, we can kind of think about data sharing in two different ways. One is the recipients of the data. So who is doing the sharing and who's receiving it? So the categories of the recipient, I think, is one way to think about data sharing. And then maybe the other issues that Arsen has highlighted here is the how. How do you do that sharing with the several categories of recipients? Do you need consent for it? Do you need notice for it? Do you have to give a right to opt out? So it's the to whom, and then there is the how. And I think maybe the data sharing section can consider those two as two different kinds of legal analysis that I think needs to happen with data sharing.
And one other thing to note is that obviously there's different examples of a type of controller or third party and service provider. And, instead of delineating every single subtype, like an ad tech provider, et cetera,
right.
7.1 and 7.2 could potentially be broad enough
That's
to
right.
cover government. Although we could just put a comma and say and or government, just to
Right.
cover our basis. But technically, you know, a government entity receiving or disclosing information would loosely be considered a controller or a third party, depending on the scenario.
That's true. That's true. So we could have very easily put 722, right? With government agencies, law enforcement as being a type of a category of recipients.
That's right.
Okay. Any questions or comments for Arsen on data sharing? If not, we'll go to our last discussion, which we will finalize with the talk about intersection. And Smita took the pen on this with me. Smita is not here to present, so we're presenting, for her. And this again is one of those catch-all sessions, I would say. And as I was working with Smita on this, we really kind of thought about like, well, many of these probably are going to be discussed in the earlier presentations, which it did. But I think some of these were not. So I think it is worth taking a small amount of time discussing what do we think about these intersection issues and what do we call it? First of all, Smita and I could not come up with the title. So we're giving the group two choices. We came up with two ideas on what to call it. You know, what do you call the intersection topics? We called it, you know, should we call it overlapping in data topics, or should we call it topics adjacent to privacy? We really kind of couldn't come up with a title, short of calling it the intersection of privacy issues. And so we gave you two options on what to call this intersectionality topics. So, you know, I would love to hear the group's thought on that. Inside this intersection of topics, we thought about 5 potential areas of law that are distinct from privacy, but have a lot of overlap. So AI laws, we thought, you know, each of these, we're really kind of thinking of it as a Venn diagram, that there is a separate set of body of law that is moving forward and moving fast. And some of that work overlaps with privacy lawyers' job, but some does not. So if you're looking at a Venn diagram, we see the overlap between AI regulations and non-privacy laws, including IP and advertising and, NIST risk framework, et cetera, ethics rules, where you have a set of laws that are overlapped with privacy law, and privacy law specialists should be aware of these regulations, but not all AI regulations would be privacy. There is a lot of IP issues that are not related to protecting data per se. So that was the first topic that we thought about in terms of the intersectionality between AI regulations and non-privacy laws and privacy. Second is squarely in IP. There are a number of data licensing and data ownership issues that, again, could overlap with privacy lawyers' job, and privacy lawyers often are asked to highlight an issue spot on IP-related and licensing and data ownership-related issues, but not everything a privacy law lawyer does would be squarely in licensing. The Venn diagram, again, there's an overlap area and there is a non-convergence area. So that's our second topic of intersection. Third area was M&A, and I did not hear from the previous presentations, a lot of focus on M&A, and I think there are a number of privacy law specialists that really specialize in deals, and not just M&A, but just in general tech transactions work. And so to the extent that there is a lot of work that a corporate attorney does that could have an overlap with privacy, privacy due diligence within M&A, post-merger integration work with on the privacy issues, and a lot of tech transactions and contract negotiations that a privacy lawyer could do and should be aware of. Number 4 is cybersecurity, and again, we assumed that this would be covered under Michael's presentation, but we did talk about, we wanted to make sure, to the extent that that group did not talk about cybersecurity, that the data breach notifications and the cybersecurity requirements were included. We did believe that this should be part of the exam specs. We just weren't sure if it was going to be covered by security. I think it is, so I would propose to remove 4 from the intersection, since I think Michael adequately included it in his section. Number 5 is antitrust and unfair competition. This is another area of law that, if you're looking at the Venn diagram, there's a lot of overlap, increasingly so. There are a number of privacy violations that are being litigated and government investigations are being brought forth under Unfair Competition or Deceptive Practices Act claims that are not being brought under privacy laws, that are not being brought under comprehensive privacy laws like the different state laws, but that are being brought under UCL and UDAP. And so again, the intersection here would be that there are a number of laws that the privacy lawyers should be aware of in this intersection area. Not everything under antitrust, not everything under unfair competition is a privacy lawyer's job. So those are the 5 intersection topics, overlapping topics adjacent to privacy. We didn't know what to call it, but those are the 5 that we came up with. I'm sure we can come up with others. These are the 5 that we try to kind of keep a short list. Any questions or comments on the intersectionality of privacy? Do you have anything to add? Does anyone have an intersection issue that you think kind of deserves, to be on the exam specification that maybe we left out? Michael, I see your hand.
I was just thinking about the name. Crossroads, intersection, you can call it nexus as well. But it's hard. I think intersection might be covering it all quite well. But yeah, legally nexus, but I don't know.
Yeah, those are good suggestions too. Anybody has thoughts about the 5 intersection topics and or what to call it, what to call the title of this topic? And I do like the intersectionality. Maybe nexus is a better way to describe it. Lindsay?
Yeah, I like the concept of topics adjacent to privacy. I mean, although I like also like the Venn diagram image. So nexus maybe is a happy Venn diagram of those two to get meta. I guess maybe it falls under M&A, but just I was thinking about contract law in general, and maybe that's too broad. So just something to think about. It's not just M&A that, privacy lawyers are brought in on deals, right? And that's a very common way for lawyers to actually get interested in privacy is they work on deals and they start to learn about some of these issues and then they dive deep into privacy.
I agree. And I think we kind of went back and forth, like M&A should really be M&A and transactions or M&A and corporate or something like that, right?
Right.
Okay. Hillary and then Michael.
So I would think also kind of adjacent to that. So I work a lot with health privacy. So, and as lawyers too, so there's the idea of privilege, like privilege between attorneys and privilege between providers of like psychotherapist and healthcare provider privilege to maintain the information as confidential. And sometimes even their ethical duties, right, that may actually contradict what the law allows. And then I was trying to think of, I had another thing that I was thinking of, and now I can't remember what it was, but yeah, that would be something I would want to think
that comes back, I love that idea. And Hillary, welcome back.
Thank you.
I'm not sure that I did justice to the previous section that you did the research and presentation on. But the first part of it was professional responsibility.
Yeah,
and,
I was there for that. I just happened to miss the part that I was supposed to present on.
Sorry about that. And so, I think privilege, Mariah, I don't recall the word privilege being part of your professional. I think ethics was, and I wonder if that belongs in the professional responsibility section, or it could be an intersection. It could really be in both. But I love the idea of really talking about attorney-client privilege, and I know that this comes up a lot, in privacy and cybersecurity, especially in cybersecurity, in terms of incident response management. The question about attorney-client privilege is, I think, one of the major issues that we deal with. And so
Yeah.
I love that idea, and I think it should be included.
I'm
So
happy
thank you
to
for
include
that.
it. It fits under a confidentiality and the duty of confidentiality. So
Right.
I had thought of it as a subsection, but I think calling it out for its own standalone makes perfect sense as well.
Mhm. That's a really good point. Yeah. Michael?
And that, sorry, well, and I just thought I remembered my other one, but it may not fit here. It kind of goes to data sharing and data use too, but kind of public records laws as well, and kind of where a public records law, right? Like the Public Records Act under California would require disclosure, and kind of balancing the privacy interests there too.
Yeah.
So.
That's a really good point. We talked about that under data use, Hillary.
Yeah.
But then I think we decided, I think Arson was okay with moving it from data use to data sharing in terms of the recipients of the data. But I think you're bringing up a slightly different point than I think what we talked about. We talked about in terms of who, can have data, who is eligible to have the data and how but I think you're really kind of bringing a different point, which is that there has to be a balancing, in terms of the risk and the benefit, and whether the data should be shared. So thanks for bringing a different wrinkle to that that I don't think was discussed.
And
Michael?
thank you. Yes, something similar. For public record laws, because I just thought about this when we were discussing contracts. There's a huge push for smart contracts. I don't think we need to have a subfield. I just thought we should at least address or mention it while we're discussing it, so we can say we discussed it. Of course, smart contracts is supposed to be on a blockchain contracts, which I don't like the term blockchain because they're just linked list databases that are fully optimized. But there was a huge push from deans of law schools pre-COVID about smart contracts. So if you have a smart contract, the main point of it is to have that online available to everybody. There was a push for that. I don't think that's useful, but it's one of those interesting dynamics of in different areas of laws being actively pushed out there in the privacy ramifications. I don't know. Like I said, I just wanted to bring it up just so we at least address or not discuss, but mention it in the grand scheme of it all.
Yeah, I like that. I know that we talked a lot about AI, but I don't think the word blockchain has appeared yet. And so
No,
the
and
question
I don't
about
know.
Go ahead.
Oh, I'm sorry, but I have very negative opinions on blockchain.
So the question about, whether, I think the question that you're raising, Michael, is, should, to the extent that there are laws that intend to regulate smart contract or the use of blockchain, should a privacy law specialist exam include that as a test topic? That's the question that I think you're raising. Mariah, do you have a comment on that or a different topic?
I have a comment on a different topic.
Okay.
So
does anyone else have a response to Michael's suggestion? If not, we'll go to Mariah. Okay.
So one of the sort of critiques that we hear a lot about certainly government efforts to regulate and get involved in data privacy is often First Amendment, right? So I do wonder if some discussion of the overlap and intersection of sort of First Amendment critique of data privacy laws might make sense.
I love it. And as we said a couple times, these were presented before, I think, last week's developments. And so thank you for highlighting that, Mariah. I agree. I think Sumita would agree as well, that I think the discussion about First Amendment could be one of the topics that are adjacent or nexus to privacy. I like that suggestion. Thank you. Any other questions or comments? If not, I would love to spend the next 25 minutes talking about next steps, which is the next section in our agenda. Does anyone have any questions about, oh my goodness, did I not finish? I did not finish intersection. Thank you, Janelle. Oh my gosh. We also highlighted content moderation. There's a longer discussion about unfair and deceptive trade practices, next is to advertising, and next is to privacy engineering. Do we have just those two slides? Let me make sure that I was not looking at the right copy when I was looking offline. I think that's it. So those are the 9 intersection topics that we wanted to include. And I think we have now added the 10th, which is First Amendment. Any questions or comments on these 9 intersection areas for privacy? Are these good? Do we have anything else to add? Do we like these 10? I'm putting 10 for First Amendment, which is a nice solid number. Michael, are you trying to say something? I think
Oh,
you're
no,
on
I'm
mute.
just reading. I'm just looking at number 6, content moderation and freedom of speech. Is that First Amendment as well?
Yeah, I think so. I think that's what we were thinking of. We didn't call it First Amendment, but I think that's exactly right. So maybe we don't have 10. Maybe that was included. Does it look like a good group of intersection topics? If so, I think we would like to talk about next steps. Michael, were you going to say something?
Yeah, I was just thinking, do you think at all that the government will make, I mean, this is more freedom of information, I guess, in public records, but I'm just trying to think if we should capture that as one of the sub points or just not yet.
Say
I
that
think-
again.
Oh, I'm just looking at public records FOIA requests, but more specifically about whether or not if government in the future will make stuff more publicly disclosed that made me feel too much sensitive information. I'm just spitballing, hypothetical.
You mean kind of like the Freedom of Information Act, kind of like the FOIA, like so basically certain data being made available by government.
Yeah, because of availability of technology, and I know at the courthouse they are OCRing much more, and they may be selling information soon. But that's probably not, I don't know.
It's
Because
an interesting thought. I'm taking notes here. So, questions related to FOIA, open data, right? Or government disclosure of data. Again, I'm trying to kind of think about what would we test on. It would be, are there laws that require a privacy lawyer to disclose data to government that the government will make public? I think that's what you're raising. We touched a little bit about that, right? In terms of public records, in terms of the data sharing under Arson's presentation. Maybe that falls under there.
maybe I just adjacent to that, there's been a push of looking at the courthouses before. There was scripting companies that script the data and they make quote unquote public data that they script to the public. And then they do data analysis from that. However, there is a push now because the courts now have affordable, more economical technology to actually then now start being able to package the data better and to do their own analysis and to sell that data. But yeah, I'm just spitballing. Like I said, it's more the current trends of technology in the past year that
Yeah.
I just don't know if we should be testing on that right now.
I
That's
think
the
what
only-
you're raising is an intersection of several different things. One, the web scraping is, I think we talked about it when Samita and I are presenting on this topic in terms of IP. So the data licensing and data ownership, web scraping was one of the topics that we were thinking about. So kind of intersection of IP to privacy. And then, once you have scraped the data, you run into AI, and the fact that AI is going to enable better use of that data after you scraped it. And so I think the issues that you're raising are handled by different topics that I think are previously presented.
Yeah.
I would like us to turn to next steps, because I want to make sure that we know what our tasking is for the next 3 months. So I'm going to share, if you could, Janelle, share with you there are 2 things that the staff, the State Bar has asked the group to focus on. One is to start sharing, if you could, Janelle, the next slides. Our task, now that we have discussed the exam specifications, the next step is twofold. One is the certification and recertification. And to decide how to do the certification, the recertification, specifically, we need to come up with a list of tasks and experiences. So this is the earlier conversation that we were having. How would we, now that we have talked about what the exam could include, how are we going to measure? And so the staff has prepared here the list of specialty areas the State Bar has approved, how the reporting is done. Do you get certain points by doing certain tasks? Are there some experiences that get certain points? And so we would be tasked to look at how the different specialty areas have outlined what tasks and what experiences would be asked in the application for the specialization. So I think we have slides here that we will quickly go through to provide examples. Clearly our area of law privacy is not going to be the same, but this gives you an idea, gives the consulting group an idea of what the other section has done. So here is an example. We're just going to show it very quickly, and of course we're going to be looking into this more closely in the next few months. So the estate planning, they have this list of task and experience requirements. And so you can see here the number of tax planning matters you have to do. How many estate plans do you have to do, and administrative procedures, completed transfers, etc. Let's go to the next slide. Practice description. You need to describe the kinds of tasks that you have done and the nature of the tasks. Other experiences, alternative and other forms of estate planning work that you have done. Allow for attaching a separate sheet if necessary. Let's go to the next page. Tax. This is the tax specialization test, and here is what they ask for. The number of years. So they ask for 5 years immediately preceding to have some before submitting the application to have done these types of matters, individual income tax, etc. Here's a checklist of the kinds of experiences that the tax specialization would require as the baseline to demonstrate proficiency in tax. Let's go to the next slide. You can check either item 3 or item 4. I'm engaged in this type of practice. Here is some, again, we're seeing here, other experience category, allowing for some room, flexibility to provide additional demonstration of specialty in taxation practice. Let's go to the next slide. Again, this is in tax to supplement the information, a narrative statement of the significant tax matters that you have handled. Next slide, is that it? We have one more. Within the 5 years, here are the kinds of things that we have done and the frequency. So here is a list of activities that you have done and how many of these you have done and how many hours you have spent in each of these activities. Next slide, please. And here is the continued list of activities: performing analysis, participation in preparation of tax ruling requests, etc. Again, the frequency, the number of hours, etc. Administrative practice, dissolution, transfers, etc. Estate planning. Next slide, please. state specifically the tax issues with which you have been concerned. For each activity, indicate, again here, frequency, number of hours spent, and brief statements about the issues involved. Next slide. Here is the form. These are the kinds of activities that we were engaged in. I was engaged in. Next slide. Check the appropriate box. I've been involved in these kinds of activities. Other experience, attached separate sheet. We're seeing a common trend here. Next slide. Here's a list of activities. I have written these tax opinions. I performed these analyses. Next slide, please. Employment contracts. We did issuance of underwriting. Next slide, please. Next slide, please. These are quite similar to the previous, so let's keep going. Okay, so here is what I think is helpful. These are the categories of experiences that estate planning asks for. So there are 5. So these are the 5 categories of experiences that the estate planning section would say would meet the specialist category, the minimum demonstration of proficiency.
This is actually, so the first slides that we went through are the certification and recertification standards of estate planning and taxation. This is now moving into the continuing education activity portion of that.
Thank you, Janelle. Thank you for stopping me. So I said there are 2 things. One is we need the task and the experience for the application to become a specialist. And then there's going to be an exam. So there are 3 pieces, right? One is you need to have some prior experience that's going to qualify you to apply to be a specialist. 2, there's going to be an exam. And we talked about the exam specifications today. 3, once you get certified, we're going to have some continuing education requirements. And so is that this one and the next one? So here is an example of the categories of, that's the tax. So the first one was estate planning. This one is tax. So we are going to be tasked in the next few months to come up with the categories. As you can see here, this is quite high level. So I think we can spend some time in taking a look at what are the categories of the type of continuing education activities that we would allow for the specialists to continue to get education credit after they're certified. And we got 13 minutes, so let me propose how we can divide our small group work and see if we can get some volunteers. So on the one hand, we need to, again, pair up, right? We cannot have more than 2 people working on a particular topic. So I would like to propose that we divide up the task and the experience that a privacy lawyer should have to be specialized in 4 areas. One is litigation and investigations, so that would be the disputes experience. 2 is in advisory and regulatory compliance. So compliance with laws, product counseling, etc. The product building. The number 3 would be transactional work and corporate work, the deals that we talked about. Number 4 would be incident response, data breach, and security. Those are the 4 areas that I think we could bucket, what a privacy lawyer does. And so we would look for 8. So 4 pairs of consulting group members to work on these 4 topics. So 8 of us would work on presenting, researching, and presenting during the next meeting. If you could go to the calendar. So the next meeting is August 15th. So by August 15th, your task would be to research and present what are the tasks and the experiences that we recommend for meeting the category for these 4 areas. Let me just say it again. Number 1, litigation and disputes. That I think would include government investigations. Number 2 is advisory and regulatory compliance work. 3 is transactional work, transactions, deals, M&A. Number 4 is incident response, data breach, and security, cybersecurity work. So could we have volunteers from us, which of those 4 topics you would like to work on? And we also need 2 people to work on the continuing legal education topics. we saw that, oh, we got hands up. So I'm just gonna call Lindsay, Mariah, and Michael. We also need volunteers to work on the continuing legal education. And I think depending on, how many people we have, I think we could get 2 people to work on that as well. Lindsay?
Advisory and regulatory compliance.
Okay, we're just gonna take volunteers and see if we are able to have everyone in the right slots. Mariah,
Litigation and disputes.
Michael,
I believe data breach and cybersecurity work.
and if I don't see you raising your hand, I'm going to call on you because we're gonna run out of time. So next in my square is Hillary. Hillary, thank you for volunteering. What would you like to work on?
Regulatory, if that's still available.
Yep, that would be with Lindsay. Is that okay?
Mhm.
So Hillary and Lindsay, advisory and regulatory compliance. Next that hasn't raised their hand. Arson?
What's the remaining options?
We don't have any takers for transactions, corporate deals. We also have an opening for IR, data breach, or opening for litigation.
I could do corporate transactions.
Okay, so I got arson on corporate transactions.
This is Soya, and I volunteer for that if we can pair up.
That's Soyan for the transactions?
Yeah, sorry, I can't. Sorry, yes, I'm on my phone, so I don't have the hand.
Oh, sorry. Yeah, that sounds good. Perfect. So yes, that would be great. So Soyan on the transactions, and I think I see a hand for, who did I just see? Jesus?
Yeah, that was me. I wanted the transactions as well, but what do you have
I'm
left?
I'm sorry, you can have that.
No,
I
that's
didn't
okay.
know.
That's okay.
It's
No,
okay. I'll tell you
no.
what is left. We
Yeah.
still need somebody to work on the legal, the certification, the legal, the CLE topics.
Okay.
Soyan or Jesus, would one of you want to take that? The CLE topics?
So these would be topics that they would have to study to maintain their certification.
That's exactly right. It's
Yeah.
basically a top level summary of everything we just talked about. So,
Got it.
all of the exam certifications need to fit into these 10 CLE topics.
Okay.
So maybe Jesus?
Yes, please.
Okay. For now, Soyan, I think you're still with corporate transactions. Okay. Paul, I don't think we heard from you yet.
Yeah, sorry for asking the same question again, but could you refresh my memory as to what's
Yeah,
available?
for now, either litigation or IR, or the CLE topics.
Either IR or litigation, or CLA topics.
CLE topic, uh-huh.
Yeah, I'm hesitating between IR or CLA topics.
Okay, do you have a preference? So IR would be working with Michael, CLE topics would be working with Jesus.
Work with me.
Okay, I mean, if you feel strongly about it, yeah, I'm happy either way. Yeah.
Was it Jesus? Okay,
Yeah,
so
yeah.
Paul and Jesus will work on CLE topics. Okay, so did I hear from everyone? I'm just looking at everyone that's on the call. So we're missing Sumita, I believe. Is everyone that's on the call been assigned? So we will follow with Smita. If Smita wants to take the litigation, the disputes one with Mariah, I think that's one that's open. I believe that's everyone, right, Janelle? And so that leaves Ryan and I to be the the floaters again. And here's what I wanted to suggest. So we have Mariah and Smita, if that's okay with her, doing litigation and disputes. So the task and experiences that we would want to see for a baseline application, right? A qualified applicant for a privacy law specialist function should have these litigation and disputes experience. That's question number one. Question number two, a qualified applicant, just to be qualified to apply to be a specialist, you must have this list of advisory and regulatory compliance experience and tasks. That would be Lindsay and Hillary. Number three is Arson and Soyan. in order to be, again, baseline qualification, just to be able to qualify to apply to be a specialist in privacy law, you must have these tasks and activities done in the corporate and transactional world. So I don't think we're going to say you should have done this many M&A deals, right? Because we know that not everyone would have done a full-blown M&A deal, but what are the baseline transactional and corporate tasks and activities that a privacy law specialist should have done just to be able to apply? IR, Michael, I think you might be, do we have we must be missing somebody. Because I know that we don't have an odd number, but right now I think, Michael, you're on your own. So Michael, you are responsible for, again, this is baseline qualification, right? Come and present at the next meeting in August 15th, that these are the baseline information security, data breach, incident response, tasks and experiences that every privacy law specialist must have done. So not something that you aspire to be, but this is something that you have to have done even, before you can apply to be a specialist. Is everyone clear on the tasking? We're talking about baseline, basic requirements, just so that you can apply even before you can take the application. Did I describe that correctly? State Bar staff, please correct me if I misstated the tasking. Adrian, if you're speaking, you're on mute.
It's okay the way you described it, but we also have to remember that you're looking at it holistically so that it's fair to all the different applicant types.
That's exactly right. And the way that I'm thinking about it, and look, I'm proposing these 4 things. I think once we come back on August 15th, we might say, hey, forget these 4 things, maybe these 3 things, right? So once we come back, I think this is really meant to be a group exercise where, the 8 of you are going to go out and think about, this is the minimum list of things that I think a privacy law specialist must have. And then we'll duke it out. We'll talk about it in a group setting, and we'll say, maybe it's not. Maybe it's not a baseline, certification. Holistically speaking, we came up with 27 different tasks and activities. Maybe this is completely unattainable. There will be 3 people in the world that qualify, right? So I think that's exactly the point of this, is that please do not limit yourselves, but do have I think a healthy dose of kind of reality check, right? Like what really does it mean to be a privacy law specialist? And if I put this forward as a requirement for application, is this really, serving the community? Mariah?
Quick question, and this goes obviously as we brainstorm for towards these qualifications. And I apologize if I missed that. Is there a baseline, like years of practice metric? And if so, what
5
is
years.
How many?
5.
5? Okay, thanks.
Yeah, so if
So
you're
Mariah,
gonna,
go ahead.
I was gonna say, I don't know if you're gonna think about that now, like the volume or the number of instances for each task, but yeah, it's 5 years of practice.
And so should we be drafting our qualifications with an eye towards what can reasonably be accomplished in 5 years? So like at that 5-year level, or should it be independent of that? So, and I ask because, as a 5 years into litigation is going to look a lot different than 15 years into litigation and disputes.
I think the first ask right now.
Yeah.
I think the first ask right now is just looking at those tasks, and then once you have all the tasks defined, maybe you'll be able to come up with those number of instances that you're expecting to see.
Okay.
Yeah.
My recommendation, Mariah, would be, and that's why the staff, gave us those 2 specialists, examples, but we should not be limited to those 2. We were, the staff thought that those 2 were the most similar, but already estate planning and tags are not similar to privacy. Nothing is similar to privacy, the way I would argue it. So please do take a look at the other specialization requirements. The way that it's phrased is 5 years of experience in, X task. That's generally how it's described. So, let's say it's incident response. It would say, do you have 5 years of experience doing data breach handling as a privacy lawyer? That's generally how it would be written, but it doesn't mean that we have to be wedded to that. I think that's a good place to start, because as Adrian is saying, generally the state bar is looking at 5 years of experience in XYZ task. Lindsay?
Yeah, I just have a question, and maybe this is for a later discussion, but are we thinking about each of these areas as a privacy specialist should complete all of the tasks and experiences in each of these areas in all 4? And I ask because there's many privacy lawyers who would view themselves as wanting to be candidates who only do litigation or who only do transaction.
That's exactly right. And so I would say for each of us, because I am asking each of you to work on those 4 buckets, to come up with what you would include in that bucket. And then we're all going to come together and we're going to say, okay, now that we have come up with 15 things or 37 things in these 4 buckets, what are we going to say is actually required, right? So we might say it's fine not to have done M&A. It's fine not to have done a single data breach incident, but 5 years of experience doing data breach is equal to doing 1 M&A, and therefore they cancel each other out. Maybe it's either or, right? So I think that's the kind of discussion that we will have, and I really look forward to having this conversation in August. And please do keep in mind, as you're doing this, as we heard from the staff, please do take into consideration what the other certification programs ask for, right? So in addition to what the other specialization areas at State Bar asks for in the world of estate planning and tax and others, do take a look at other security certifications or other organizations that do privacy certification, to take a look at what do other certification programs require for pre qualification to apply for a specialist designation. I think that would be a good background to have, and to come to the next meeting to discuss why you're proposing something that's similar or different than what is in the industry. I know that we're out of time. I think we have room for one more question or a round of comments, but before we depart, I wanted to suggest, since Ryan and I are going to be floaters, we're not assigned a specific topic to present on, would it be okay if the 2 of us took the pen in looking at the exam specifications that were presented by everyone today and trying to streamline it? So for example, we talked about how sharing could move here or use can be moved here. Did we forget about how about freedom of speech? So there were a lot of comments that were very good comments today. Could the 2 of us take a look at coming up with a clean copy for the group to consider during the next meeting? Would everyone be okay with that?
That sounds
Adrian is
great.
nodding his head. I'm seeing thumbs up from everyone.
That sounds
Ryan, I'm
good.
sorry, I just volunteered us for that. Are you okay with that? Is Ryan still on? Did we lose Ryan? I might have just signed him up for something and he's not even on. I'll make sure that he's okay with it. But it sounds like that's okay from a staff perspective. So I'll try to take good notes and come back with a clean copy so that the group can consider it. So that would be the agenda, Janelle, Adrian, if that's okay with you. Michael, do you have a question or comment?
Comment. Just let me know if anyone else joins me in my topic.
Yes,
Pretty
will
much it.
do. Yeah, I'll make sure that we didn't lose anybody, because I'm scratching my head here. We shouldn't have an odd person, but for now it's just you. So I'll let you know if we lost a participant. So everyone is clear. We'll come back on August 15th. Janelle will come back to you with communication on drafts when the drafts are due, so that Janelle and the rest of the staff can prepare the presentation. Otherwise, we'll see you in August. Thanks, everyone.
Thank you. Bye.
Yeah.